Yes, yes, madam.
The Lordship's kind permission. But this is supposed to be a no mention day. Matter pertains to medical admissions, my lord. Counseling will commence on Saturday, 5th.
Which category?
Medical admissions, postgraduate admissions. But now the state government has carried out an amendment to the existing
When have you
rules.
filed the petition?
But today, it's ready.
You have filed?
No, I'm seeking permission to move a lunch motion, my lord.
No, have you filed the petition?
No, I'll file it now.
Please file it, then mention.
But it's ready to be filed.
No. We cannot in anticipation. Perhaps this is too much.
With leave of your lord.
Yes.
Writ appeal 746 of
No,
20.
but she doesn't read out of it. They will read first and then they mention like it was read yesterday. Why are you not reading, madam? You have.
No, first page wise mentions, then we will.
Yeah,
somebody
like
started,
yesterday.
So don't continue that.
Yesterday we did it like this, no?
Oh, I'm sorry.
No, but today's date is no mention.
Oh, no mention day.
No mention.
No mention day.
Only problem is
So
the
no
No
mention.
mention day.
founding of a passport. Writ appeal is numbered but not listed.
Tomorrow.
It was directed to be listed today.
Mr. Which appeal? We will get back to you.
I'll come back to that. I'll get in touch with you.
Yes. He will tell you.
One of due respect, I am not informed. I cannot get the file.
No mention day, Mr.
No.
He's saying he has not been.
That is
informed
not
of the
passport
mention
matter.
Passport matter.
In fact, my lord, I understand that is obviously interrupted or not by the electrical jet.
Tomorrow then, Mr. Senior
That-
Counsel.
Papers have been served on him.
No, but he hasn't got the file.
I'll
He
give him
didn't got-
another set. I'll give him another. I'll give him one.
No. Tomorrow can we take?
Tomorrow, that's right.
Tomorrow.
Tomorrow.
Yes, Mr. No mention day, Mr. These are all why we have entertained, because there was a date given in his matter which is not listed. No mention day. Come tomorrow. Please come tomorrow.
Wednesdays, no mentions unless until, in all the courts, unless until some particular court, because it's a no mention day, some demolition disposition is there, we are permitted to make a mention only before the first court.
You
That's
are-
the-
Today. Which case? Give it to him. He will look into it. Provided this bench has jurisdiction to hear your case, right?
Just check why it has not.
He will
been
check.
said. It is there.
Why mention on a no mention day? You can mention tomorrow, right? That event has passed, right? Don't we, by encouraging this, we don't want to convert a no mention day into a mention day. You can make it tomorrow also. House not being demolished. Is it being demolished today, now? No. Your house is, in that sense, any urgency which cannot wait for next day. Fine. Yes, madam. Yes. Yes, please. Nobody is there. No. None for petitioner. What we say for it?
None for petitioner, list after 2 weeks.
List after 2 weeks. Next, madam, 130 motion. You have to be fast today. Take the next case in your hand. Yes. None for petitioner.
Same date, same date. That is-
List after 2 weeks.
Yes, election.
Huh?
The council is selecting from 3.
Yes. What do you say?
What is the
Personally interested because their lands are very same village.
So you are agreed, right? So don't, I mean, it can't be a PIL, you file a writ petition. That is understandable.
Lordship's candidacy, illegal layout was made in respect of the Sitaram.
Your land is being also affected, right?
River
So
land.
you are an agreed person.
Lordship's candidacy. Illegal the encroaching the river land and the.
No, this is on an office
illegal layout
objection.
was made and
This is on an office objection saying that You are aggrieved by the action of formation of layout, so it can't be a PIL. You can file a writ petition, please. That's all we are saying. Convert this bill into
I'm
a.
not personally agreed by that.
This is
Lordship,
what-
my candidate said river land was encroached and illegal layout was made.
But the village tank is being illegally converted into a
Yes.
layout. The government has given a permission for that.
But why, what is the office of personally interested, which current?
Merely because.
I have
he has
also
got
tried
a
the
same
photographs to Lordship, my
village.
candidate
He
from
is established
pages
village,
54
therefore
onward.
He is personally interested.
Which, as he said, where I am not personally into this thing.
He said.
Where the statement that you have not this thing,
Lordship,
no.
while the photographs also.
In
Lordship,
view
my-
of submission made by learned counsel for the petitioner, office objection is ignored.
This objection is overruled.
Over
Registry is directed to
register, number the PIL.
list in due course, list in due.
May I please, Your Lordship? May I please, sir?
Ah,
Because this PIL relates to removing the sports quota from the admissions of medical and BDS courses, the admissions into the medical and BDS courses. 0.5% of
who
sports.
are you?
The petitioners will have.
Public spirited individual, that is the standard answer. But whether the petition contains a statement that persons aggrieved by this GO are unable to approach this court on account of their poverty or illiteracy.
I have mentioned one fact, my lord.
No, no, tell us. Are they so poor or illiterate that they cannot come, and therefore you, who is a public spirited individual, alone can come?
In another way, I have mentioned this Geo 75, Indian Geo is not even placed on the website of the government.
Correct?
At the SAG end, when.
No, are you a candidate
No.
seeking admission under a sports quota?
These persons, Millet, are interested in sports.
Ah.
Their children also have participated in sports. Millets, they are not seeking any personal prayer, Millets,
Oh,
for.
no, but the persons aggrieved by, in our opinion, you will have to explain. These principles have been laid down as recently as in Balwant Singh Chaufal's case, and this thing, Guru Ayub, 2003 principles were summarized, 2010 again reiterated, and we are sure that in 13 years they must again have been reiterated. What is the one of the principles? That the petition in public interest should be filed for benefit of a person who, on account of his either poverty or illiteracy, is unable to approach this court. We are not for a moment saying that the challenge is unfounded, right? It may be merit based, but if your son is under a sports quota, you can very well file a petition saying that this office order, this government order is arbitrary, unreasonable. 14, we will examine that. But PIL,
They did it this way. I have mentioned in the petition that the children are eligible for sports quota.
get anyone,
But they are not interested.
get anyone.
My claim,
If nobody is interested, why are you fighting proxy?
For whom are you fighting, Mr.
Proxy.
Jaiswal? We
for
are not
the
interested.
public in general.
You want to make
0.5% of the sports quota millets, thousands of persons are eligible for this. They strive for this. 3,000 crores rupees have
No, no.
been spent on this.
we will pass an order on the maintainability of this public interest
Will
litigation.
not grant me liberty to convert it into a writ petition.
That's what you should have said so. You understand, right? Learned counsel, you withdraw with the liberty to file. All this can't be converted. Learned counsel for the petitioner, after arguing the matter to some extent, seeks leave of this court to assail the validity of a government order dated yes.
This appeal is filed against the.
Yes. Petitioner repeated details of earlier litigation and recalled.
Kindly look into.
Yes,
But common judgment, Milord, Your Lordship, kindly look into
Ah.
page number 8 onwards.
no, so an order passed on an earlier occasion has been recalled, right?
Yes.
Ah,
Yes,
Why it has been recalled?
Because the-
Petitioners in subsequent writ petition were necessary and proper parties
Ready.
not included in earlier writ petitions. Secondly, details of previous litigation not disclosed.
Yes, yes.
In other
That was
words,
not disclosed.
we are being mild that you are guilty of suppression of facts.
Milord, your lordship, that was the observation of Lord Singh.
These are incorrect. These are incorrect.
Yes.
Both of them.
It is correct.
Petitioners were
Yes,
implemented.
it is correct.
Petitioners were implemented in your writ petition.
Milord, your lordship, that is my obligation also because your
Which
lordship.
respondent? They were which respondent in the writ petition?
That
Learned
was-
single judge has wrongly held that they were not implemented. That's
Yes.
the contention.
Yes,
Where is it? Which writ petition you had filed earlier?
Milord, your lordship, earlier petition 22041 of 22, Milord.
Where is that?
Milord, page number 8, Milord, common order, it was extracted, Milord.
No, not earlier writ petition.
Milord, earlier writ affidavit, Milord, your
Earlier writ
lordship,
petition.
earlier writ affidavit, kindly look into page number 23, Milord. 23, Milord. The unofficial response, who are the, unofficial respondents here were not made party. That
This was the
affidavit,
earlier writ petition
22041 of 22, Milord.
So where these persons Yellappa and Vade Lakshmamma were parties,
Milord, your lordship. They were not made party.
then
Milord, your lordship. I am not saying that.
you said yes.
Milord, here,
You said that we are asking you, you said yes, they have been implemented. That's why we are looking at the cost title.
no. I am not saying that.
Two grounds, Mr.
Yes.
Please explain. Two grounds the review petition has been allowed, that petitioners in subsequent petition were not implemented in earlier round of litigation.
Yes.
The order has been passed behind their back.
Yes.
63 Supreme Court says that such an order
Yes,
cannot
yes, sir.
bind them and they are entitled to seek a recall by way of subsequent writ petition.
Milord.
Number one. Second is that you are guilty of suppression of facts.
Milord, your lordship. That,
Please explain this.
Milord, for that, Milord, your lordship, the council, Milord, your lordship, the party is innocent. Milord, he brought to the notice of the, Milord, your lordship, the council did not brought to the, notice of the learned single judge.
File a complaint against the council in Bar Council.
Milord, your lordship.
You know it.
Making a complaint, Milord. At that time, the rule position has been changed, Milord. That is the Telangana.
In position change that material facts need not be
Yes,
brought
yes.
to the
I'm
notice
not
of the
saying
court.
that. Here, Milord, your lordship. Milord,
Please deal with him. I don't know. Yes, please let him work. Yes, go ahead, Mr.
Milord, your lordship.
We hope that you have understood what queries we are
Milord.
putting you. Yes.
Milord, we understood the.
See, the earlier round of litigation and the orders passed by this court has not been disclosed in the
Yes, yes.
writ petition affidavit filed,
Yes,
which resulted in the learned single judge passing an order.
yes.
By filing a review petition, it has been brought to the notice of the court by this present respondent,
Respondents.
saying that these facts have been suppressed and thereby playing a fraud on the court, and order has been
Yes.
obtained.
Yeah.
The learned single judge found that is one of the ground of review is justified and allowed the review petition.
Milord,
There is nothing wrong, Mr. Kankaya. in
yes.
that.
I'm not saying that. Only the thing is now option is, Milord, what happened? Now he has to go to civil court for the mistake of, Milord, the council, Milord, he has to
See,
make rounds.
don't-
Only that is only, that is my submission.
Mr.
Understand.
Kankaya, one thing, don't allow, for the sake of parties, don't take the responsibility, because tomorrow, if this kind of practices are allowed, he's
Yeah.
going to make allegation against the
Yes, sir.
council
The
also. Now,
council, sir.
that he has not argued his case well.
Milord, your lordship, here only the thing is.
Don't do that. Don't encourage
Milord,
this kind of
the
practices.
picture, his lordship justice, your lordship, Naveen Rao has passed an order. Justice Naveen Rao order was not brought in the affidavit. And not made the unofficial response. That is mistake, but I am not saying that. Only the option, Milord, now the problem is this, Milord, again he has to go to the civil court. That is only the, let me explain a
No,
observation.
so he need not go to civil court. We declare the rights, his rights in this writ petition under Article 226. This is
Milord,
the prayer.
I am not, I leave it to your lordship, at least protect the interest of the party, Milord, that is how to get rid, because it is a mistake committed by the revenue authority. I am not saying that, Milord.
So it will be open for you to approach the civil court with regard to your grievance. That we will clarify. This intra-court, correct, Mr.? To that extent, we agree with you that his rights should be protected so that, but no interference is called for. This,
Milord, if that is the
This-
case, Milord, I may permitted to Mr. Dhamira.
Ah.
It doesn't require. any-
This intra-court appeal has been filed against an order dated 3/3/2023, passed by learned single judge in WP number 220. Same, both, Mr. Same.
Correct.
Okay.
The license I'm appearing for respondent number 112.
First time somebody been called, stood up and later said to withdraw. No. I didn't declare that. I'm waiting for that. But yeah.
Oh, yes, better. Madam, it's getting better. Yes.
Lordships,
Huh?
we have filed, this Supreme Court has been dismissed, Lordships.
Yesterday, it has been, day before yesterday, it's been dismissed by his lordship.
We'll
Justice
comply with
Chava.
all this, Lordships, we are in the process.
How much time?
Lordships, 3 weeks time may be given, Lordships. At the earliest, we'll do it, Lordships, because that's what is requested. in
Mark the presence, learned counsel for the appellant submits that SLP filed before Honorable Supreme Court against order dated 14/3/2019, passed in WA number
Board is lit.
Oh. Don't make it like today, 130, right? 23rd, we have been fixing. We say 3 weeks. That doesn't mean that immediately next day after. So whatever you say, according to the, see,
You can go to,
all right.
just see the board.
Then please see and then give a date. Not necessary that only 3 weeks as soon as they are over, you have to. That's what we are trying. Yes.
Material.
Yes.
The appeal against the order of the commercial court.
Yes.
There is an appeal ag-
Protection. Getting pursued.
there is an appeal against the order of the commercial court, my lord, under section 9 of the Arbitration Conciliation Act. Hyderabad
Section
High
9
Court
petition has been partly allowed.
partly allowed,
Ah.
directing the appellant respondent
All right.
not to, my lord, deduct certain amounts for certain, my lord, items of work which is recommended by the independent engineer for deduction.
Hmm.
Come out of the 53rd annuity payable to the respondent. I'll just give lots of a brief background of the case.
As we understand, the order is restraining you from making recoveries in
Yeah.
respect of
Certain
counterclaims which have been rejected in the award. So logic appears to be simple that you cannot effect recovery in respect of a claim.
One aspect is that there was no rejection of counterclaims. In fact, we have withdrawn the counterclaim. The learned judge doesn't notice that.
So
we have withdrawn those counterclaims before the arbitrators.
Counterclaim withdrawn.
Yes, man. At 274 of the paper book, your lordships will get that letter. Be that as it may,
When it was withdrawn? When it was withdrawn?
It was withdrawn before the award was passed.
When?
During the course of the award. I'll just give you lordships the date, 17/8/2020.
17/8?
17th August 2020.
All right. So then what's the order?
Award is dated 31st October
2010. All right. So please read last 3 lines on this of the order which under challenge.
Yes. In the result, petition is allowed to the executive lords want me to read.
Yes.
To the extent that the respondents are directed not to make any recoveries of the counterclaims rejected by the award dated 30/10/2020. And those works are, those counterclaims are enumerated. And out of these counterclaims,
and thereafter it reads further also, till disposal of COP 5, it is made clear that this order is not a, please read the whole thing.
That's 2 minutes. I'm sorry.
So you want us to read, we will read, please give us 2 minutes.
Till the
Made clear that
I'll read it.
not a direction to payment of this, clear that this order is not a direction to payment 23rd annuity, same time it does not bar to make payment 23rd annuity. Not a bar, no direction. Okay, so the deductions are these 7, 8 items are also only interpreted them till this disposal. Yes. So far as 23rd annuity payment of everything is concerned, is not interpreted. No direction in fact, he should not have written. It would have done it because it's to contribution was. So we put on claims and any other dispute regarding 23rd annuity. No section with regard to claims of 23rd annuity, right? Yes. He is not given. But this is it has been withdrawn. What is the difference? He said 274. 274.
Clause 70.
In the arbitration award, where is the withdrawal recorded?
It's in the award minutes, last page. I'll just give lots of the page number.
It's not perhaps not there at 274.
That's our withdrawal letter.
No, 274 is not.
274 may have.
In our copy, at least, I mean, unless you have some different copy, we don't know. Our copy 274.
234 minutes, I'm sorry. 234 apps.
Yes. So what's wrong with the order?
This letter, is
correct.
rather inelegantly drafted because
Correct. So what's wrong with the order?
The learned trial court completely ignored clause 17(2) of the agreement, concession agreement, which enables the employer to recover the amounts wherever there are pay the amounts, wherever the independent engineer suggests additions or reduction in the scope of work.
No, as we understand from your this thing, you have not read it, the order, despite being asked. So we understand.
I'm
that-
sorry, Manoj,
no, no.
that
We understand. There was a
Last
purpose for asking you to read, not that we have not read it. There was a purpose behind asking you to read something. We understand probably you could have relegated this task to your junior counsel to read, and then you could have proceeded with the submission if that's the case.
So that's not the
this-
case.
no, no.
I didn't
So-
want to.
the thing is that you had made a counterclaim in respect of items number 128
Yes.
here in the concluding paragraph of the order. That counterclaim you withdrew on 23 on 7/8/20.
That's true.
Then how can you say that this thing I will recover it? Having
I'm
made a claim,
entitled to recover under 17(2). But if my recovery is bad, there is an option available to the concessionaire by way of invoking arbitration
so
clause.
is it your case that you made a claim, a counter claim inadvertently in ignorance of your powers to recover the amount?
But
Is
that's
that
not
the-
what the letter states.
That,
Manoj, we just said we are withdrawing because Manoj, because of
that should be the like case, right? That
Pardon?
we were not aware about our powers
May I
to
invite you
recover the
to
amount and
attention-
inadvertently made a counter claim.
Manoj, clause 17(2) of the,
Without prejudice, have you withdrawn it without prejudice?
no,
That,
no,
that,
no. May I invite your lordship's attention to clause 17(2),
which page?
17, 152.
150?
2.
152. Yes. Yes.
Starts at page 1. Lordship have it. A change of scope of order will be effective and binding upon the
So can you not approach the commercial court and bring to the its notice all whatever is being argued? That was not perhaps the case argued before commercial court. Is it correct?
It was pointed out, Manoj, in our,
Where is that?
it's we have said in our counter affidavit, Manoj.
No, order.
Order, Manoj, order doesn't refer to.
Then this the effect of senior
Manoj, I am
counsel appeal.
in appeal because Manoj,
Senior
I pointed out
counsel appearing in an appeal. So all
Manoj,
new grounds.
in an appeal,
Not-
Manoj, your lordships will consider what's the stand taken by me, Manoj, whether the trial court has really considered the stand. My stand was, Manoj, notwithstanding the withdrawal of
All right,
the
so-
counterclaim. We have filed Manoj,
Mark the presence.
we'd also filed written submissions before the.
Mark the presence, learned senior counsel for the applicant. Heard on the question of admission. This appeal
Looks at the order of the last 3 lines of the order.
However, what I appreciated that under clause 17, uh,
Two.
point 2 of the concession agreement, comma, the appellants had power to recover the amount due from the respondent. Full stop, in view of offences submission, notice, personal service, whatever, affidavit of service, what
Right.
complete proof of service.
Right.
Date,
How much time for service?
service, how much time?
2 weeks, Malad.
That's the only point, right?
That's true. That's all. I
Can
told
we,
one of the companies that the liquidation responding.
can we have it
That
on
our car.
22nd? 22nd. 22nd.
22nd August.
But the other one we have given, need 12 matters, so that's not given.
Yes.
Okay, so they were supposed to, that GO, master plan GO.
Yes.
What happened?
We have addressed, we have deputed the officer also.
Material papers, you were supposed to file something.
Master, they said, but land is a master plan. So, yeah, even there is the GO. Has it been gazetted?
But
It
even
has not
it is
been gazetted. So how does it become a concern?
Since yesterday onwards, Malad, we
GO
have,
has not been gazetted, correct?
but that
Then
written
what's wrong?
instructions I could not get.
Huh?
The written instructions, Malad, I could not get, even though Malad, we have addressed letter to the second respondent.
Your clients are not interested in pursuing. Why are you pursuing? If they are not interested, you see, you can take a horse to the water, but you can't compel it to drink. So it is like that only.
Correct.
Malad, we have addressed a letter to the second respondent, Malad, to give written instructions whether the GO was gazetted or not.
No, read, I mean, para 5 of the order passed by learned signature.
Yes.
Several writ petition, other coordinate benches repeatedly rejecting building applications.
Yes.
Huh?
Malad,
You
that was-
invite them to meet your officers privately, that is understandable.
No,
But forcing them to come before this court, you won't help your officers, right?
that was Malad, prior to Malad passing of Malad the GO.
Yes. Then which GO you are relying on?
Malad, GO 55.
Huh?
GO number 55.
55 dated
17/3/2022.
17/3
2022.
25
22, Malad.
22. So what is your case under this GO? What?
Malad, under this GO, Malad, the road width was approved by the government.
Huh?
The road width was approved by the government.
No. So under this GO, what he can't do?
Malad, he is Malad now seeking Malad building permission. Malad,
Building permission can't be granted.
he granted Malad because Malad that Malad place Malad is Malad going Malad in the master plan Malad 2021. 2040.
Some other purpose.
2040.
Fine.
Road width Malad is not Malad
Become part of the
mentioned by the
being affected by the master plan.
That it is earmarked for some other purpose in the master plan of 2020.
Not be with master plan. Road width will increase so that his land, part of the land will go away. But that master plan is not notified.
Fine. Yes.
My submission is
Mark
Malad, the GO was not under challenge. In spite of that, Malad, the learning Singh judgment.
GO has not been notified, Mr. At least you have to be fair to the court. Say so. It has not been notified.
Unless
This intra-court appeal is filed against 10. Huh?
Second part.
The appellants have filed writ petitions, which is forming part of a batch. But all of the batch of writ petitions were filed challenging the exorbitant increase of fee being charged by the Pharmacy Council of India for granting of affiliation, which is an annual affair. But we've challenged the
Ready? No?
increase.
Ready?
Yes.
Yes.
Appear for the second part.
Worship, I am for respondent number 1. Pharmacy
Notice
Council
is
of
yet to
India.
be issued, right? Huh? Just to make out a case for this thing.
Yes.
So, Mr. So far as increase in the this thing, levy issued. Acha, notice has been issued.
Yes, Lord.
People are ready.
Second part.
Yes.
First party, we not contested in the process.
I am ready, Lordships.
So, Mr. So far as issue with regard to increase and this thing, quantum of fees concerned, you have to show that it is confiscatory, right? It's not your case that the authority has no power to frame regulations, right? So what is your case? Authority has no power
Well,
to
my
prescribe
case-
fees. What is it?
But my case is that the Pharmacy Act does not prescribe a fee. There is no charging section for the Pharmacy Council of India to charge fee. Number one.
No
Charging section, which empowers them to frame regulations, which enables them to charge fee under those regulations.
No charging section in Pharmacy Act.
In the Pharmacy Act.
Oh, all right. What else?
On the second ground, the entire exercise of increase was only to circumvent the moratorium orders which were initially passed, which were set aside by various high courts, and ultimately the Supreme Court also passed an interim order asking them to consider and grant affiliations for fresh colleges. So, to circumvent that particular orders, they've sought to exorbitantly increase the fee. Because initially they wanted to increase the fee and also charge security
What was the previously the fee?
Your Lordship may kindly
Has it
take
been increased by 500 times? What is the fee?
Plus now it is about 100% for a few courses.
Earlier.
And for about
What is
in fact,
what was the previous fee? How much it has been enhanced so
Yes.
that we understand, right?
Your Lordship may kindly take a page number 66.
They tell the fee.
Because initially under the 2018 notification, it was 1 lakh. Now it is increased to 2 lakhs for B-Pharmacy.
1 lakh per college.
Yes. Yes. 1 lakh for college for one course. And for Farm D, it was 50,000. It was increased to 3 lakhs. For M-Pharmacy, it was 50,000. It was increased to 1
you said 1 lakh for one year. No.
1 lakh for 1 year. Yes.
Of which college? Which course? Is it be course wise? No.
It is course wise. Page number 66.
66.
I've inserted a table in my data.
Please. Yes.
Initially in 2018, it was 1 lakh.
So it is enhanced to 2 lakhs.
2 lakhs. B-Pharmacy,
50
for Farm, 50 to 3 lakhs. For M-Pharmacy, 50,000 to 1 lakh. Diploma in Pharmacy, it is 50,000 to 1 lakh. Plus that is the increase which they sought to make. Plus this was initially challenged on
that ground. I mean, we are on the grounds, right? So first ground is that there is no charging provision in the Pharmacy Act.
Yes.
So therefore, by way of a delegated legislation, no fee can be prescribed.
Yes.
Correct.
The regulations say that the regulations are framed under section 10 and 18 of the Act. Lordship may kindly take up the Act, which is at page number 180. I have filed a copy of the Act as well as material waivers. Section 10.
Page
185. Subject to the provisions of this section, the Central Council may
do one thing, right? You have told us 2 grounds. Now you are elaborating these submissions.
Yes, I
You are
have
making a
grounds.
new ground. So please tell what we would appreciate. You are a young council. That's why we are telling you what we would appreciate. You say my submissions challenge to this is 1, 2, 3, 4, 10 grounds. Then you elaborate.
Yes.
So you tell us that this and then start reading page 185. We don't understand what context you are reading 185. So are you just a minute. So tell us what other points you have.
Yes.
So we appreciated that no charging section and increases as exorbitant.
Yes.
Number 3.
The entire exercise was undertaken to circumvent the moratorium orders.
Which moratorium order?
Plus, there was a moratorium order passed by the Pharmacy Council of India where they've taken a decision not to entertain any new applications, any fresh courses for any colleges all across India. This came to be challenged in various.
Pharmacy Council is a party.
Yes, Lord, sir. That's one.
Who appears?
I'm appearing for Harvard, Pharmacy Council of India.
Ah,
Yes, Lord.
all
This
so,
this notification, well, I'll elaborate on this as well.
so
Because
these patients, what else? Number 4, anything else?
Because there's no correlation to the fee being charged by them and the services being provided by them. And I've also filed material papers to show that there has been, they claim that they need financial resources for providing services. But I'm able to show from their own balance sheets which were available in their website.
What else?
That almost 100% increase in their resources in a span of 2 years, from 2018 to 2020 alone.
No justification for increase of fee.
Yes.
What else?
Plus, all of these grounds. And the last ground is that the fee is already fixed for a block period. There's a GO which is passed, there's an authority, TAFRC, Telangana Admission Fee Regulatory Committee, which fixes a fee for a block period where it prescribes a fee which the college can charge from a student.
All right.
Which of these institutions are required to pay because but we will have to consider this.
This fee you don't recover from the students, right?
This fee we are not able to recover from the student because the fee is already fixed.
You pay.
Yes, we will have to now pay because these were recently.
It is the expenses which we have to show. Justifying the fee which TSHC will fix for each student is like we admit this.
All right, we'll admit this appeal. Learned counsel for the heard on the question of admission in this intra-court It's not that you can't afford. If you can't pay 2 lakhs, then you better go bankrupt. Stop, close the
Right.
institution. What is?
That's
You will be, pharmacy council will run away.
right.
Like,
That
and
is
it
fine.
is, tell us, pharmacy council is at flight risk.
That's the
Perhaps
issue.
they would have spent more amount in this litigation than the
Fees being charged. One officer flying from.
lighter vein, mister. Don't this thing.
Plus the other issue with this, Manoj, is during the pendency of the writ petition, Manoj, an interim order was passed
No,
suspending.
we are not
And
entitled
various
to all.
all-
Give,
No,
you want an order, then
No,
like,
I'm
we'll have
not
to pass.
pressing for an order. I'm not pressing for the other interim order. Manoj, I thought, I'll leave it here.
Yes.
Come back.
Then say needless to state that any recovery made from the appellants in pursuance of the impugned notifications shall be subject to outcome of this appeal. Accordingly, IA number 1 of 23, 2 of 23 and 3 of 23 are disposed of.
Obliged, Lord.
Obliged.
Good. I mean, this is how you should argue. Elaborate, Mr. Counsel. Tell that I am aggrieved by these notifications. They provide this. These are the grounds. Then you elaborate. That first point is like this. You say 163, 185. We don't know what is 163, 185. You know. The court should know, right?
Okay.
You should explain that this is what I want to say beforehand. So we appreciate, we understand the context in which we are seeing page 163. Otherwise, there is always an element of suspense. What is at 183?
Okay.
Right, all right. Usual course list. Usual course. Yes.
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 Pay for the appellant balance. Pay for the appellant. So the
Yes,
last
yes.
petition, this court has directed me to produce the original sale deed balance. The original order dated 27/6/23.
Oh, something has been said about you, right? Learned Singh, this is a writ appeal, right? Yes.
This means the readable minutes.
Fine.
Though minutes, two persons are claiming the very same plot.
Para 17, please read and then we proceed further.
Married minutes. The relief that is sought by the petitioner in this writ petition is that the unofficial respondent is making illegal construction and the third respondent is not stopping the said illegal construction being carried out by the unofficial respondent. Even as per the counter of the official and unofficial respondent, when the unofficial respondent want to go ahead with the construction basing on a simple sale deed and also based on a complaint of the petitioner, the official respondents are taking steps for demolition. But as on today, this has been not.
No, please go ahead. First read, then expert comments follow later on.
When it comes to the case of the petitioner has not stated about any facts with regard to the earlier permission granted rectification deed, revocation of permission and cancellation of earlier sale deed, etc. According to the petitioner, as the earlier sale deed has become redundant, he has not mentioned the same. The contention of the learned counsel that this court is not able to appreciate is not about the sale transaction becoming redundant. Revocation of building permission is a very crucial factor. On the face of it, the petitioner with an intention to obtain orders from this court has suppressed the material facts. When the counter is filed on behalf of the official and unofficial respondent, the petitioner has come up with these all facts. The issue of the fifth respondent is concerned. It is already stated that the official respondents are taking steps to demolish the illegal structures made by her. As far as the petitioner is concerned, he has approached this court with unclean hands since he is not entitled for any from this court. That's my grievance before your order.
Suppressed facts, unclean hands. Why we should interfere?
May make only one submission.
Everybody has a grievance, but you are under an obligation to approach this court with clean hands and not to suppress facts. Why did you not disclose? That itself is.
But it has no bearing on the deciding of the writ petition also. That is my respectful submission.
Why you did not tell the learned single judge these facts which I have suppressed have no bearing on the controversy?
That is what I have said. The sale transaction has become redundant, so we have not mentioned in the writ appeal.
You decide, right?
May make only one sub. Both the appellant and the unofficial respondent claiming the very same plot. Both obtained building permissions on the very same plot. Both permissions were revoked.
No. your grievance is that despite revocation of building permission, he is raising construction.
Yes, ma'am.
This is the
He
grievance.
is not demolishing the structures as on today.
No. So he is raising construction, therefore he be restrained. You are the owner of that property on which he is raising construction.
By virtue of a sale deed. Once I am holding a sale deed, once
We are trying to understand. You claim to be the owner on the basis of a sale deed in respect of a plot of land which is in his possession and he is raising construction. You want this court to issue an order of injunction under Article 226 to restrain a private individual from raising construction.
no, but permission was already revoked, but demolition was not taken up. That is my grievance.
Okay.
There is no challenge to the revocation order as on today. It's been more than a year. Revocation of building permission was done.
So, Mr. So what facts have you suppressed?
But earlier, my vendor has executed a sale deed. Based upon that, I went for permission. But unofficial respondent has filed a complaint basing on that they issued a show cause notice. I submitted an explanation. But my building permission was revoked. That is not stated in the writ of private.
Building permission in respect of the same plot.
We also obtained.
That is with respect
For same plot,
Same.
where construction is being made.
Yes. So that was revoked.
But that plot size is 200 square yards. Plus later on,
Is it not a crucial fact that there is one plot, say, like this book is a plot. Both of you are claiming title. You apply for building permission, that is granted, revoked. Then he applies, it is granted to him, according to him, that building permission subsists, according to you, it is revoked. You approach this court by seeking demolition of construction raised by him, right? You do not tell the court that you had earlier sought a building permission which has been revoked. Is it not a material fact, Mr.?
that sale deed was mutually
What will
cancelled.
be your remedy?
That sale deed was mutually
Seek
cancelled.
an injunction restraining him from raising construction in a civil suit.
But there is no permission as on today. Municipality is not.
Seek an injunction.
That's
He is a private individual against him.
That is also private individual and senior counsel is appearing.
Nobody is appearing.
I appear for the unofficial respondent.
You are raising construction. Why are you sitting?
But as again, I'm sorry, but I thought my turn has not come.
Not coming. Okay. You be in his company, right? Like
in fact-
you are appearing for petitioners.
Municipality.
You have not filed any appeal. Then go there, right? This side. You better know. We have put this thing. Yes.
A separate notice has been issued, my lord, in respect of the
What
construction.
building permission has not been
But
cancelled?
what has happened is, my lord, there are two plots, plot number 26, plot number 6, which are adjacent to each other.
Plot number?
26
Ah.
and plot number 6,
Ah.
back to back, my lord, in the same layout.
All right.
I have purchased both together.
Oh.
Right on plot
When?
and 1983-1 and 93-1.
What
What has happened is
83, 93, 1, which when?
My lord, I'll give the sale deed number.
All right.
My lord, one is registered sale deed. Another, my lord, is,
83 and 93.
my lord, I'll give the exact
All
number.
right. Yes. You give then.
Then, my lord, plot number 26, the sale deed was registered.
All right.
Plot number 6, my lord, because it was paid in installments, while I paid the entire thing, agreement of sale was entered into, sale deed was entered into, but that was not registered. Now, my lord, the person who has already sold to me, his children, my lord, cannot claim the land under section 53 of the Transfer of Property Act, even if it is not registered. Those persons try to create a third party sale deed.
Your vendor's children.
Vendor children, after my vendor passed away, but they create one transaction in favor of a third party, but this part for the same 200 square yards plot, but which is prohibited under section 53 of the Transfer of Property Act, because they cannot claim. But that I bring to the notice of the sub-registrar who has not verified the title and registered the sale deed. Action is taken against the sub-registrar, and his one increment is stopped. Then, what they realize is with the same boundaries, they register another plot. Why 69 square yards? Because, by this time, the Telangana state.
No, out of this thing carved out of 26 and 6.
But they mention a different plot number, but the boundaries they mention the same.
This children had created by way of a third transaction. What had created a third party interest in respect of somebody.
In respect of somebody.
All right. So
But-
then what happened?
I gave a complaint stating that this 200 square yards document
So they executed a sale deed.
sale deed in favor of this person. 200 square yards. That is the first document that is suppressed.
Appellant. What is the date of sale deed?
Yes. Suppressed document number 1, that is the date is 2021. Date
Ah.
20th November 2021. First document which is suppressed.
What is 20th?
20th November 2021.
Ah. Number 2. Yes.
Then, my lord, after that, when I give a complaint, what they do,
Complaint to whom, Mr.?
the sub-registrar.
Ah.
But what they do, the same parties again register the same plot.
Same
but
party
now
means sons.
the sons,
Children.
children in favor of the same appellant.
Again register.
Again,
how can there be a second
that is
conveyance?
what. Now, my lord, they register 69 square yards. But the reason why they mention 69 square yards is Telangana now.
Earlier it was 200 square yards.
200. Now, my lord, they make it 69.
What is the date?
That date is February 1st, 2022.
1/2/2022.
February 1st
to
1st February.
1st February 2022. Next document here. But this also, my lord, I make a complaint showing that
this is also suppressed.
This is also suppressed.
Not suppressed.
But I'll mention. I'll mention it. Then there is a third document. I make a complaint saying that this is also contrary because the boundaries that they are mentioning, area that they are mentioning is not matching. Then they, my lord, change it to 61 square yard. Now, 8th February. My plot is admittedly 200 square yards. That is 8th February 2022.
Rectification.
Rectification deed. But now the 200 square yards has become 69 square yards and then 61 square yards.
This forms part of which plot? 26 or 6?
They call it joint plot A in one document. When they file a caveat.
So it's part of both the plots.
No, no, no. It's only according to their claiming only plot 6. But part of plot 6. But they are mentioning it as something else totally called joint plot A.
Yes. So then he applied for building permission, that was revoked.
That was revoked. The reason
and
is,
that also suppressed.
Yes.
Then what he says, you were granted building permission when?
My building permission was granted
14th February 2020.
Yes. 14th February 2020.
So what is it?
But there are 2 building permissions.
What are?
In plot
2 and Mr. Senior Counsel, 14/2 and which date?
14/2/2022.
Then which other building permission?
The other building permission is on plot number 26. That is not disputed.
All right. So this is, you were granted in respect to plot 6.
Plot 6, which was revoked in the ground.
Revoked on?
Revoked
February 2020.
February 25 to 2022. On the ground that the document is not a registered document. But my respectful submission is that would have to be separately challenged. Because the municipality cannot go into the question of type.
So you have challenged it?
That has not yet been challenged.
You will challenge it?
I will challenge it. And
you will raise construction in accordance with that, whatever?
Yes, but separately the construction
in
that is
accordance
made,
with law.
Notice issued, a writ is already pending.
Mr. C, you are investing your money and everything into this plot, right? You would ensure that it is in your client's interest, apart from his conduct. He is an unscrupulous person. So apart from his conduct, we are putting it to you that it is in the interest of your client to ensure that the construction is raised in accordance with law, so that tomorrow, not only him or anybody else, even the municipality also cannot raise any objection or corporation, right?
We already
So you say that this building permission has been revoked, and you will take action to challenge it, and subject to result of the outcome of these proceedings, if it is order is quashed and your building permission is revoked and you revives, or there is you will raise construction strictly in accordance with the building permission. End of the matter.
Yes.
Yes.
That's
correct.
Yes.
So shall we dispose it off?
Yes, it may be.
Basing on a simple salient means municipality has granted building permission.
This is Mr.
It's not
Questions
registered
of
document.
title cannot be adjudicated. If you speak a word more, we will impose costs. Order is already 15,000 has been imposed. You want it was to be annexed? Did you understand or you didn't get it?
That was revoked 1 year back, Malas. Till now, there is no challenge. He has already completed the construction.
Well, the construction merit is shop
Malas, I
at the
filed
border of
programs also.
All right. Then, all right, you are inviting order on merits. You want to file SLP, right? All right. So, so it has been revoked. So what is the status of construction?
but if there are small stores where they have sealed. They've sealed.
What have you done after this? You have not challenged the order dated 25 to 2022 for 1 year. Why?
Yes, Milord, that is yet to be challenged. But
Why?
Milord, what happened?
1 year is construction
I,
is stalled.
I agree, Milord, that they have not challenged it yet.
No, but what is the status of construction?
Milord, they've issued a notice for demolition that has been challenged. The writ is pending.
Notice for demolition.
Demolition of the existing already constructed portion has been issued. Writ has been filed. Been challenged. Status quo order has been passed.
Construction. When the notice was issued?
Well, this was issued on 13/6/2023.
And what happened to this thing? The construction is not complete.
That petition.
Just a minute. Construction not
complete in total.
So you have not undertaken any construction after 25th February, right?
No, Milord. 13th June 2023. Notice was issued and the status quo order was passed in a writ petition challenging that. That writ is pending.
When was it passed?
That writ petition, Milord.
No, order, you said.
Yes,
13/6. 13/6.
Well, 13/6/2023.
Notice.
After this writ appeal, Milord,
notice was issued. Then where is the interim order passed by this court?
Milord, that is not on record because Milord, that is
Date
after.
of order.
Milord, the date of order, Milord, is.
So how can they take action for demolition if there is already an order?
May make only one submission.
Nothing submission. You see, Mister, we don't want to hear a counsel who doesn't, a party who doesn't approach the court with clean hands. How can this relief be granted to you in the petition, even if, I mean, there is an order of stay, that this thing, how can the municipality should have said in the first sentence, he should have said, he is looking at the file now, then he should have said that I can't take in any case, I cannot take action because of an order of stay in the writ petition.
Yes. That is.
When was this?
20th June 2023.
WP
number 15462 of 2023.
15462
of 2023.
2020. Yes, madam. Right. Mark the presence. This intra-court appeal emanates
Yes, thank you, appearing for the respondents in this particular matter.
I'm for the
Officer.
appellant, Milord. On the last occasion, I was.
You had told us some case law, right?
Yes,
Yes.
So you said that it applies.
yes. My lord.
No, Milord. The
Does
act
not-
cannot be made applicable to minority.
Which para of the
My
judgment?
lord, still look at it.
The question is whether.
I have passed it on the judge.
1 minute. See, let us, this thing capture this.
Yes.
Last date, the issue involved is whether RTE Act 2009
Can be
applies
made
to
applicable.
minority educational institutions.
Institutions or not.
Right.
Yeah,
That's the question.
yeah, that is the only question.
So what is, you
Before
said
issue, my
that,
lords.
1 minute.
Sorry.
Do you think you will not be heard? Huh? Who has filed this appeal?
I have filed appeal. So.
Who should be heard first? You have this thing, you are confident that you will be heard, and without hearing you, no order will be passed. You want to seek an adjournment?
No, my lord.
Then who will argue first?
My lord.
Why are you interrupting even when he has not opened up his mouth? Yes. So, Mr. You
Yeah,
said- just a minute. So you told us on the last date, 2012 6 SSC page 1
Yes,
is the judgment which says that it will not apply.
not applicable.
Which para?
Below at page, 65 paragraph.
Page?
Page will not 44.
Internal.
However, findings, my lord, I am reading. However, the said Act 2009 Act and in the particular section 1E and 18.3 infringes the fundamental freedom guaranteed to unaided minority schools under Article 31 and consequently applying the RMD Chambarwala and Union of India principles of severability, the said act shall not apply to such schools.
Which was the question involved in this case before Supreme Court, where the question has been formulated? Which para?
Milord, the matter was further referred to a 5-bench constitution bench, Milord. From page 45 onwards, it is there, Milord.
So what happened to this judgment?
Milord, this judgment, Milord, when so far as the first judgment is concerned, it said that it will not be made applicable to unaided minority institutions only. Then the matter was referred by the Pramati Education and Cultural Trust. There, my lord said whether it is a minority institution.
1 minute, please give us. So got it. So yes, Mr. So what happened to this judgment?
This 47, my lords, may kindly look at paragraph.
No,
47.
not para 47. What we are trying to ask you is that what happened to this judgment 2012 6 SSC 1? This still stands.
That
Is
was-
it not? 1, 2, 3. Three
That was-
judge bench.
That was superseded by this judgment, which was referred to 5 judges bench. They held it that it will not be made
This
applicable
this
even
judgment-
to aided schools also, it will not be made applicable. That is what my lords have heard.
So why are you relying on a judgment which has been superseded?
No, my lord, I was chronologically, I wanted to submit. Initially, it was only
No, we thought that this issue covers, right?
Yes.
So it was again referred.
to a 5 judgment
3, 2, 3, 4.
and para 47, my lord, last page.
1 minute. Para?
47, my last page.
Hmm.
In the result, we hold that the Constitution 93rd Amendment Act 2005 inserting clause 5 of Article 15 of the Constitution and Constitution 86th Amendment Act 2002 inserting Article 21A of the Constitution do not alter the basic structure of the framework of the Constitution and constitutionally valid. We also hold that 2009 Act is not ultra vires Article 19 1G of the Constitution. We, however, hold the 2009 Act insofar as it applies to minority schools aided
Got it.
or unaided.
So therefore, this issue is answered by Constitution bench.
Yes.
In your favor.
Fine.
Now your turn, young
Hello.
man. Yes.
My lord.
Perhaps you
Lordship-
cannot argue contrary to Constitution bench of.
No,
Supreme
I
Court.
won't argue, my lord, because Article 141 is totally clear with regard to binding precedents by the Honorable Supreme Court on all the lower courts. My lord, but one
No,
thing,
this is not a lower court.
my lord, no,
Please, for your
Constitutional
benefit,
court.
this is not a lower court.
my lord.
Supreme Court itself has defined the relationship between Supreme Court and the High Courts as being elder brother and younger brother.
Yes.
Don't say subordinate court.
My lord, I'm really very sorry.
So, Mr. You should say yes, it is answered. What can you argue against the Constitution
My
bench
lord,
of Supreme
With
Court?
regard
Fine.
to the ratio of the judgment, my lord, sir, one submission before your lordship. Ratio of the judgment. Because my lord, Honorable Supreme Court in some of the educational institutions had dealt with regard to the admissions are concerned. Your lordship may kindly see.
So we are asking for submission.
My lord.
What is the submission? This Constitution bench does not apply.
My lord,
No, what
in
is?
the entirety of the act, my lords, that has to be decided. The sections which clash with the Article 31 and Article 15(5) does not apply, but the entirety of the act, my lords, it is the issue which has to be decided, which has been considered by the Honorable Learned Single Judge, my lords. My lords, the thing is, the Honorable Supreme Court
the continuation yearly.
So,
my lords,
what submission?
my lords, the ratio descending, which has been decided in this particular
No,
case.
first submission. We will understand the ratio. What is your submission?
My lords, this act is not applicable as per section 16 of the RTE Act is comes into consideration, my lord, because as section 16 of the RTE Act, my lords, doesn't.
Ask him what he means. I mean, I haven't.
How do you say
Well,
that the judgment of the Honorable Supreme Court is not applicable to the facts of the case, or is not a ratio decidendi for us to follow, not to tell us?
My lords, the act is applicable to all the aided, unaided, as per
Fine.
the,
We will record your submission that the act is applicable to them. Fine,
my lords.
fine.
But the ratio descending,
Mr.
the reasoning in this,
Instead arguing for another minute, it will 10,000 per minute.
my lords.
Student of class 3.
Yes, my
You
lord.
should be ashamed
My lords,
that contesting a claim of student of class 3 who was short in attendance on account of COVID, and you are this thing. Huh?
my lords, it happens to the factual aspects, my lord. The contention
Right.
raised by the student is, my lords. The lordship permits only 2 minutes, I'll.
20,000, say 2 minutes.
My lord.
Yes.
I was not permitted to attend
Mr.
the class.
Advocate General, you are here incidentally. This is what we expect fairness, right? The issue with regard to applicability of RTE Act to private minority uneducational institution is answered by the Constitution bench. Despite that, we have a counsel who is arguing. At least, I mean, he should realize that he should get the matter to Supreme Court, argue there that this Constitution bench is incorrect, get it referred to a larger bench of 9 judges. What can we do? This fairness, I mean, should also be. Huh? No, but we are telling you, we will have to hear him. But see, here is a man who is arguing despite Constitution bench. Go ahead, Mister.
The young man.
This young man, he should. But young man should not waste energies at this thing where it is useless. What submission, please?
My lords, my first submission is, my lords.
You have read Constitution bench judgment.
Yes, my lord.
So we will say that after going through the constitutional bench judgment, following submissions are made. Number 1.
The constitutional bench has dealt with regard to the applicability of the RT Act as per section 12(1)(b).
Read para 47.
46 of the judgment.
47 of the judgment.
My lords,
Read.
47 of the judgment, my lords. It is clear.
No. So you are not coming to the submissions, right? The submission is what?
My lord,
The act applies.
the act,
Then
the act applies.
what else? Second.
My lords, the second submission.
Second is act applies. Third is act applies.
The constitutional bench.
What, mister?
The constitution.
No, in a case which is debatable, we would definitely, it will be our pleasure to hear your argument. But this is wasting time, precious time of the court, which I told learned advocate generally.
I leave it to your lordship.
We will record your submission.
No, I leave it to your lordship.
No, don't leave. We will say that your submission is that it act applies. And you have reiterated twice, how many times?
I leave it to your lordship. So lordship.
No, don't leave. Is it not covered by constitution bench?
My lord, this particular.
You are saying you are arguing the act does not apply. And we are not sitting here to convince you in any case. Until you understand, supposing if you realize at 4:30 p.m., that means no other case is taken up. We are stuck up on this case only. We can't do this.
All the provisions will have. Once the 2009 Act has been held to be, will not to be ultra vires, all the provisions in the Act stand up. Therefore, your claim today, the Honorable Supreme Court was only considering applicability of section 12 and not 19 cannot stand. That's all. This is the issue which you need to deal with.
Then your lordship, I don't have a case at all.
Correct.
Then I don't have a case at all.
Now you have realized.
Now I will tell you one more thing. There was a challenge, a writ petition filed under Article 32 for the similar relief that was sought, that has been sought by you, that has been rejected in 2022 by the Honorable Supreme Court.
All right. Yes, ma'am. Mark the presence. The issue involved in this writ petition. On admitted facts, the issue which arises for consideration in this case is whether the provisions of this all Right to Education Act 2000, write the whole name, Act 2009, apply to a minority aided, unaided educational institution, question mark. The background facts are that son of that respondent number 5, represented by his father, was a student of class 3, Roman capital 3, in Little Flower High School. According to respondent number 5, due to onset of COVID-19 pandemic, he could not pay the school fee and was denied and was not provided access to attend online classes and was not permitted to attend online classes of class 3 by the school. Thereafter, the respondent number 5 was not permitted to appear for the final examination of class 3. Full stop. The being aggrieved by the action of the management, you say school, herein after refer to school, in not promoting the respondent number 5, a complaint was filed before Telangana State Human Rights Commission, which Telangana Human Rights Commission, the district educational officer requested the deputy educational officer to submit a report after conducting an inquiry in relation to the aforesaid complaint. The deputy educational officer issued a show cause notice dated 26/9/2022 to the school seeking a reply as to why contrary to provisions of the Act, 2009 Act, hereinafter referred Act, the student was detained in class 3 and is not being promoted to class 4. Thereupon, however, the notice failed to evoke any response from the school. Thereupon, a reminder dated 25/10/2022 was issued by Deputy Educational Director. Full stop. The school took a stand that the provisions of the Act do not apply to the minority unaided educational institution. Full stop. The deputy educational officer submitted an inquiry report dated 27/10/2022 to district educational officer, concluding that management of the school is has submitted irrelevant answers not justiciable as per the rules. The district education officer thereupon issued proceeding dated 30th/11/2022 stating that the provisions of 2009 Act are applicable to all schools, including the unaided minority educational institution, and directed the deputy educational officer to issue notice to school to promote the student to class 4 as per section 16 of 2009. Full stop. The the school has assailed the aforesaid proceeding as well as the order dated 30th/11 has assailed the order dated 30th/11/20 had assailed the order dated 30th/11/2022 in WP number 45940/2022. And what was the other petition? 3372.
The student himself has a file.
Full stop. The student filed a continue. This order was passed when?
In June.
Look, the moment the orders are passed by the district educational officer, I filed the writ petition number 45940 of 2022.
No. What happened to after the order?
After the order also, the student was not allowed to enter the school. After 5/6 also, he was not allowed to enter the school.
Hey, Mr.
Effectively, they are not implemented the order by ensuring that the student is not allowed to at school. So, would have been if actually wanted this technique, but they will permit.
So when has the academic session begun?
In the month of June.
June
second week.
So, Mr. We want you to make a statement in the peculiar facts. This is, I mean, this is law is in your favor. That's correct. But against whom you are fighting? Class 3 student?
No, we asked him to join in class 3.
mighty educational institution fighting against a
No, no.
small student of class 3? Does it?
It's not like that, Millard. We asked him to join in class 3.
Where is that?
Millard, I have stated
No,
in
no,
my
not class 3. He wants class 4.
Yes,
Where, then where is the petitioner in that case?
he will be in class 3, Millard. We have no objection to admit him in class 3.
Not class.
Him to repeat class.
Repeat class 3, right?
Millard, for 1.5 years, he did not attend this school.
What? Yes. Jointly. So, being aggrieved. Being aggrieved, this appeal has been filed by the management. Paragraph. Learn it. So there is an order directing issue of notice. You find out where is that person, or we'll have to issue notice then in that case.
He is appearing.
You are appearing for the child.
Yes, my lord.
So, have you taken admission in other school?
No, not yet.
We thought you are a government advocate. You should have said that I am appearing for the child.
Found that I am appealing for respondent number 5.
What, Mr.? Yes. So, what has happened now?
Now they have, even after.
Unfortunately, the law is against you. We have all the sympathies, but please appreciate we are bound. Now, say they did not permit, right? What happened to you? Whether child has been admitted to?
No, has not been yet admitted in any other school till now, my lord. He is
Why?
still, after passing of the order, as it was passed on 5/6/2023, academic year started. We tried to inform the school about the same, the said order passed by the Honorable Learned
Mr.
Judge.
You accommodate the child in this case to 4th standard. We will say it will not be treated as precedent. We will allow your repetition. Be magnanimous enough. Peculiar facts. COVID comes in a century. It will not come next year. Right? Be magnanimous. You are a mighty institution. Please do not fight.
Yes.
We are this small young child.
I understand that.
We do not want him to grow up with litigation like a law student appearing in the interim orders, senior counsel appearing in the examination, seeking declaration, completing his. We don't want him every year to be here. You admit him to 4th standard, and this thing is your statement, not this thing.
But so far as the Education Act is concerned,
Mr. Law is in your favor. We have accepted it.
Yeah. Education Act.
No, you get back to us. Seek instructions that you have a humanitarian approach. We are saying that this will not be treated as precedent, and we are declaring the law. We are declaring, that's what we told him. So what your argument should have been, young man, that sir, please permit me, the student, to promote to be, and that may not be treated as precedent, instead of arguing against constitution bench.
I'm sorry.
Got it?
Yes, my lord, I've got it.
The object of whole exercise is to ensure that you learn something.
Yes.
If you are open, otherwise we can't help it.
I got it.
Mr. Fee has also been paid. Take a humanitarian approach.
Let them make a representation, Millard. I'll ask the management to consider.
So we will ask them, who is your district?
Pardon me, Millard?
Who is your person?
Correspondent of the school.
Brothers. We request him, you ask him that court wants to interact with you.
Very good.
If you can't convince him, that we will do our best.
I talked to the man.
You got it? I mean, we are inclined
to the manager.
See, we are bound by the constitution bench.
I understand. In fact, one of the first writs on this subject I filed. I'll talk to the management about the admission of
boy, I mean, he has taken a defense that on account of COVID, I couldn't go to school. They are not promoting him to class 4 on the ground that he has not paid fee, and like your client, short in attendance. But thankfully, he has not taken a stat. No,
fortunately, in this matter, I'm with the
lighter vein, we are saying that fortunately this young man was not advised to take this thing that law requires biometric attendance. School is still going by the register manually, and my name is not deliberately written though I am present. Lighter. Please, you understand the
I'll
situation.
talk to the management and come back.
Yes. So afternoon, if possible. The young boy, that's why.
I'll come.
The
I'll
law is
come.
in his favor. You speak to, with your intervention, we are hopeful that,
I'll talk to him.
yeah. With your peculiar, we will safeguard. We will say that we will record your statement that he will be done. This will not be treated as precedent and the law is in their favor. That we have to answer, bound by the constitution. Paragraph. What? Paragraph, we have learned counsel for the appellant, learned counsel for the school submitted that the issue is no longer a integra and is favor, but this peculiar facts,
I'll speak.
many people have lost their jobs in pandemic. His father may not have been able to pay fee.
I know the institution for a very long
Yeah.
time. I'm surprised this happened
Ah.
because it's a very humanitarian institution.
You are known for that, right? So these institutions are known to have a humanitarian approach. They won't
I'll just come-
like to this thing fight with a small little student, right?
Right from 2021, Miller, he didn't attend the class.
We
That
are
is
not
all.
asking, we asked you did not avail of the opportunity. Learned Senior Council was good enough to intervene. We appreciate this. He will make a statement.
I'll also.
But do it. You should have said that. You should have said yes. These are two appeals, right? No, this 12 and 13. So appeals are displayed, right? So you should say which appeal has been in the aforesaid factual background. 1 minute. Yeah, 1 minute. So aforesaid the factual background you have written, the appeal has been filed. There you said WA number so and so has been filed by the school, whereas so and so has been filed by whatever education director. Yes. Fine. Do it. Allowed. So right. Yes, please.
Wanted us to revert back by 2:10.
Today, we 2:30 we'll take it up if you can, so that we complete our order.
Right.
So we are waiting for you, 2:30. And of course, the student will also wait. Yes.
My lords, with your lordship's kind permission, item 14 to 17. While as the matter involves regarding a state largesse, my lords, the single judge has, in fact, my lords, committed patent error in the matter of appreciation of the facts of the case. My lords, a checkered history is there. My lord, the earlier round of litigation.
I appear for the respondents.
Ah.
I appear for the respondent.
Yes,
petitioners. There is a delay, my lord, in these appeals of 129 days.
So we condone that delay, of course.
Your lordship.
You won't oppose that prayer, we are
I
sure.
won't.
Yes. So we condone the delay and hear you tomorrow at
Day after tomorrow.
Day after
tomorrow. I'll file a small.
Is it convenient? Day after?
Your lordship, may I kindly have it either tomorrow or on Monday, my lord.
Monday, your lordship.
Monday. Mark the presence, learned Advocate General and learned Senior Counsel. Counter.
May it please, your lordship.
And 2014-15 SLC page 197. 197.
May it please, your lordship.
14-15 SSC.
2014-15 SEC.
197. Please see, give 2014-15 SCC. So nobody represents, they have not been served, right? Respondents.
I'm in 18, item 18.
Who appears for respond number 2? Not served.
They are all served, your lordship.
Served. Nobody appeared.
Nobody has appeared even in the last.
Is the decision of Supreme Court saying that Human Rights Commission is
Yes,
not
your lordship.
competent to deal with question of
Yes, your lordship.
title, possession or eviction?
Yes.
What is the judgment?
The judgment, your lordship, is that G. Manikyam may pass on the copy of the judgment.
Copy.
Citation.
Yes. Citation.
Yes, I. Para 44 and 45, your lordship.
That's what we were trying to find out. So.
Yes, Your Lordship. The Honorable Supreme Court has held that the Human Rights Commission cannot involve itself in the title disputes of the property. Para 44, Your Lordship. The functions and powers of the Commissioner enumerated under Section 12 of the Protection of Human Rights Act 1993, which reads as follows. And thereunder, after extracting Section 12, Your Lordship, the Honorable Supreme Court has said it can be seen just above the para 44, 45, Your Lordship. It can be seen from the language. There is nothing in Section 12 which authorizes the Human Rights Commission to adjudicate upon disputes of title and possession of property. Apart from that, there is neither any examination or any determination by any competent body of the rights of the first. This is with respect to the fact of that particular case. My respectful submission in so far in this particular case is concerned is, I happen to be the landowner who has given my land to the development to a property developer, and under the supplementary agreement, villa number 12 has, villa number 23 has fallen to my share, and some third party who has grievances against the so-called developer has lodged a complaint before the Human Rights Commission.
Who lodged the complaint?
The complaint is lodged by one Mr. Anil.
Second. Respondent number 2.
Respondent number 2, Your Lordship.
What is the complaint like? What was his grievance?
Yes,
you are the owner of a villa.
I am the owner of the villa. I am actually the landowner in where the villas have been constructed. And in terms of the supplementary.
So what was the complaint by R2?
The complaint by the R2 is he has paid some monies. There was an oral agreement between himself and the developer that he has paid some monies to the developer, and that the developer has allotted him this 23, the villa number 23, and thereafter the developer has what is called not delivered the villa to him, and therefore he himself has entered into the villa compound and entered into the premises of the villa and took possession of the villa. It is a narration. And that as a landowner, as the villa owner, when I tried to interfere, he rushed to the police station. He did not lodge a complaint there. In a state of confusion, he has come to the Human Rights Commission, and the Human Rights Commission says that.
Yes, madam. Mark his presence. None for respondents those served. In this writ petition, the petitioner inter alia has questioned
Yes, for the respondent in matter. We intend to file an additional counter notes. I request 1 week time.
You got that Karnataka judgment authored by my
Fortunately for me, it,
Justice Shetty.
yes, it echoes what I'm canvassing. for.
That's why. All right. Mark the presence, learned senior counsel. You appear for
I appear for the respondent bank. Mr. V.
which respondent?
Yes. I appear on behalf of Mr. V. Jumani. who is a-
Sole respondent. Learned counsel for respondent. Press fund is granted.
1 week time.
A week's time to enable him to file counter. Which date? He supposes that they find
Next
something.
Wednesday.
The fact that without issue of notice, they are seeking time to file counter means they accept that it's a debatable this thing issue, right? Bank could say,
There are multiple judgments in my favor now.
obviously. Yes, list on what date? 14th
Nine.
August. 14th August.
14th, I have some inconvenience. I'm going to the High Court where your lordships were present. I have a matter in the Bangalore High Court.
Oh. But we have never heard you in there in Karnataka.
I always appeared before the single judges there, and by then I think your lordships were in the division.
Division bench. Okay. So, no, we heard Mr. Hanumanth Rao in this thing. I heard sitting in division bench. So, which date?
14th is okay. Otherwise, we can have it on 16th.
16th August
or 17th would be.
17th.
17th. List on 17th August 23.
Lords, just two things, my lords, I just wanted to clarify in this matter. I know your lordships have adjourned. Your lordships asked my colleague last time, why is it challenges to the rule? Because the language in the rule, because of your lordship's interpretation, stands where it is today. If a strict reading would show that liberty was not there, that is why we said read down the rule. And the other matter, my lords, the principle is already applied.
Of course, we would apply reading down principle at first instance, and if not possible, then only.
Yes. And my lords, in the other matter, the principle is agreed.
Yes.
I'll come back at 2:30.
2:30. Yes. Yesterday we had passed an order. Yes, madam. SARFAESI Act. Order is applicable under section 18.
Lordship,
No adjournment. No.
He is not well, your lordship. He asked for 1 week, your lordship. Senior counsel worked as.
No. What happens to Satyavati Tandon and other judgment? In 1 week, it will not be overruled, and Supreme Court will say that you should entertain the petition against an order passed by DRT.
Your lordship, kindly 1 week may be granted, your lordship.
Do you understand what order has been challenged?
I'm handicapped with the file, your lordship.
Then don't appear.
No, your lordship.
The case is listed before us. We have taken oath to do justice.
Yes, your
right?
lordship.
We have taken the oath prescribed under the constitution. Don't appear.
Pick up tomorrow, your lordship.
Better.
Yes, your lordship.
In this writ petition, the petitioner has assailed the validity of order dated 9/5/2020-23 passed by the Debt Recovery Tribunal under the provisions of SARFAESI Act. Full stop. When a query was put to learned counsel for the petitioner about the availability of alternative remedy in view of law laid down by Honorable Supreme Court in Satyavati Tandon versus so and 2022 judgment. Yesterday we dictated, right? So and so, learned counsel for the appellant prays for petitioner prays for short accommodation. List. Tomorrow, what is the position?
Already.
What should we do? Monday? Monday. List on. With the condition, no further adjournment. Don't come with the without file to this court.
Along with 25 and 26, your lordship.
No, wait. Monday, date. Next, on 21.
I appear for the respondent number 1 and 2. I need to file counter 4 weeks time is granted.
Learn it.
And with
Your lordship, normally your lordships would have seen by now. I never object to time.
No. You
This
file
is the
counter-
transgender matter.
Yes, you file counter not 4 weeks, 6 weeks. But
Madam.
what happens to our interim order? Who is respond number 6 matter?
Interim order.
No. The peculiar thing about this case is it's coming up for the third time in my short tenure of 8 days here. The thing is, just a minute, please listen. The interim order stands. Nobody has filed any application seeking vacation of stay or its modification, right? And the fact remains that every day of hearing, senior counsel has been making a grievance that it's not being implemented. This we can't be tolerated, right? This non-compliance of an interim order in the absence of an application seeking vacation or modification. Somebody, if respondent number 6 is not responsible for implementing, respondent number 6 should have said so. Who appears for medical counsel commission?
My lords, with your permission.
You are there.
No, my lords. On the last occasion, my name was wrongly recorded for respondent number 6. I am only for the National Medical Commission, respond number 5, my lords. Medical Counseling Committee.
Mr. Yes, what happened?
Personal notice is now issued to,
Mr. Ravichandar, what happened to 6? Have you served it?
yes, sir.
When?
SR number 71755 of 23.
Proof of service filed?
Proof of service filed in SR number 71755 of 23.
May I?
717?
Indulgence.
71755 of 23.
May I seek indulgence, sir? Because, this comes from the Minister of Health and Family,
No. What is the interim order? We are not allowing the petition today.
With respect
We are
to
granting you time. The only thing is,
with respect to 6,
please see, it is, what is 20th 6 2023, 1 month ago, long order was passed by the then division bench.
My lord.
Read the order. If you don't have, we will supply you a copy.
My lord, with respect to respond
Please
number,
read.
with respect to respond number 6, my lord.
You are not appearing.
No, my lord, by this order 6, my lord, Minister of Health, my lord,
He says that they have been served. He has filed a service certificate. We want to know who appears for 6.
my lord, I'll get instructions from the my lord, 6 respondent, because who is there? If nobody is there, my lord, I'll take under my lord.
No, so 6th respondent is central government.
Yes, that's right. That's working under central government. Therefore, my lord, I need to get into instructions, my lord, because.
So you have to give extend the comply with the interim order.
My lord,
Fine. That's the issue. That's the concern. He doesn't mind. You take 6 weeks.
because my lord, notice is not, I have not received notice. I have not received notice. That's why, my lord.
Learned. We are directing. Mark the presence. Learned senior counsel for the petitioner submits. We are directing.
First August and April 27.
And the NEET PG and state counseling and the counseling for the courses under the central quota and the state quota for Mr. We have issued a direction to the state government as well as state, this respondent number 6 counseling committee, and to you also. It's a joint direction. You cannot get away by saying that I am, that's the problem. That you see, that's the problem. State government says we can't do it. You say I can't do it. There is an order since April. Then we will, just a minute. No.
My lords, that's not correct. Respondents, particularly successful, all respondents.
Now you have understood, right? The direction is direction. Please understand. No. Did you not hear the order? So we will repeat for your benefit. We have issued directed state government respondent number 6 as well as 8. So that, and we have asked you to file a compliance report. This order, don't ask. This order is open to special leave petition before Honorable Supreme Court. No. Don't ask. No. We don't know. That I don't think that when a court passes an order, you should ask the court how to implement this order. That's what you're doing.
Well, this one,
we will deal with that aspect in contempt. That we had asked you to deal with and ask you to do an impossible thing. That argument reserved for in contempt proceedings. If you intend to file a compliance, this is what it is to be worked out. This is eventually for a benefit of a student, Mr. Don't in all the cases necessarily you shouldn't adopt an adversarial approach. This division bench of this court has passed an interim order running into passed an order assigning reasons running into 9 pages, and then comes the direction. There is no application seeking modification or vacation of stay, and despite that you have guts to ask this court how to implement. We are amazed. That's the ingenuity on the part of the council. This you say that in contempt you reserve when you don't file this thing. Two remedies. Well, two remedies. We told you SLP, second contempt submission, that we can't do it. We will not tell you how to do it.
Just 2 aspects before your lordships go to the next one. Your lordships has said compliance by what date?
Compliance on or before next date of hearing. We don't know, Mr. There is an order. There is an order passed today. When you will do it, how will, don't, this is, Mr. No. We don't want to, we are telling you, we don't want to go into all this. Otherwise, you will quote us in saying that after order was dictated, I had asked your lordships orally told that we can do it after this thing. That's why don't put us in embarrassing. Whatever is the order is the order. Please copy today and delivery. What Karnataka we say, here we say what's copy today.
Yes,
CC today.
There's 2 items. There's an IA.
Start drafting
The IAs will have to be ordered. The IA for 4 is for amendment and
taking into account the
additional
nature,
documents.
4 of taking into account the nature. In the beginning, you
IA 5 is for additional
amendment for the reasons assigned therein. Same is allowed. Registry is directed to carry out the amendment.
Yes.
Who will carry out the registry?
The council will carry.
Council. Amendment shall be carried out within a week.
The only other thing is, my lords, while dictating the order, your lordship said my case will be considered under the state quota.
What is the order?
Your lordship said
quota.
No, both. I'm entitled to both.
No, but
state and central quota.
Central quota held yesterday. You told no first.
It started yesterday.
So counseling, madam, then read. You should have told us then. Read the order. Submitted that.
Just.
Before that, submits that the counseling for filling up the seats under the central quota of NEET PG 23 as commenced from 1st of August 23 and state quota is scheduled to be held on 4/8. So therefore, direction is central quota and state quota as well. Right.
Obliged.
Next.
My lord, I am for the petitioner, my lord. Yesterday, respondent number 1 paid, respondent number paid the amount of yesterday, my lord.
Oh, that's good, right? Learned counsel for the petitioner submits that the grievance of the writ petition, mark everybody's presence. Good beginning, Mr. Grievance of the writ petitioner stands redressed as the amount of GPF has been paid to him yesterday. In view of aforesaid submission, nothing survives for adjudication in this petition. Same is disposed of. CAP category.
Category, BSF, CRPF.
Oh, that's the order. We have the order, right? Same in your case.
No, but there is no order.
No. You don't know the order?
That may not work out to be, because there's no spoke to special government leaders, who represented in the last year matter. He said he would speak to government and get back to this court whether
Government wants to.
page 43 order.
Who is the special?
You are like DCF. We told you BSF, right? You don't come under the rules. You have not challenged the rules.
But
what relief?
But it's the special government leader would speak to. Your lordship may put it to Monday and Tuesday.
You are a person. Your father is serving in BSF.
Yes.
BSF.
I am CRPF. Last year was BSF. Last year was BSF.
CRPF.
Now the petitioner is the daughter of.
Yes, madam. Learned counsel. Mark the presence. Learned counsel for the petitioner submits that petitioner's father. You are seeking adjournment. We have adjourned to 7. They are saying we have no instruction. They are opposing your prayer. Please point out the rule under which you are entitled. That's it. This PIL you have to. Who has to file counter?
Lord, all the pleadings are over, Lord. Over matter, Lord, the two
No,
petitions, one
you have
year-
filed, counter by 6 and 7 has been filed.
Yes, Lord.
1 to 5. 1 to 5, you do no formal, it's forest, right?
Forest, Lord, the R5.
How can you be formal? You
Lord,
say so.
After
District collector.
district collector or medical and health?
No, you say so that you don't want to file any counter on 1 to 5. 6 and 7 is on record. We will proceed hearing. You effect of non-filing counter, you know, for these persons, averments made in the petition will be accepted against you. Petition is, we will deal.
You filed a counter.
6 and 7.
Respondent has filed a counter.
Lord, the sixth, Lord,
No, Mr.
number 1 to 5 are the forest.
Again,
department.
same thing, right? Same thing you are doing. 6 and 7 have filed counter. 1 to 5, you tell us you want to file or don't go.
Contesting respondent.
5, 6 and 7 have filed.
Contesting, Lord, contesting respondents are the forest department, Lord.
So 1 to 4
Respondent
do
number
not
1.
want to file.
Respondent number 1, 2 and 5 are the forest department. We filed the counter twice, my lord. One is on 26th August 2019, it's filed.
1 to 5.
1 to also forest department.
1 to 5.
1 to 5.
And 6 and 7 also filed.
Yes.
So then 3 to 4 and 8 do not want to file any counter.
In the pleadings are over, my lord, except pleadings are over, my lord.
Presence, yes.
My lord,
the grievance is
appointed the
just a
amicus
minute.
curiae.
You are amicus.
I'm the
Then who is amicus?
amicus, lord, is on Divya. She's
Yeah.
I report, lord, everything is.
Mark the presence grievance in this public interest litigation. But
Taken up independently. The subject matter is entirely different.
which one? 24
25 and 26.
No, we are at about 24.
My lord, item 24, my lord, I am the appearing behalf of the petitioner counsel, my lord, I requested next week, my lord,
No.
because he due to the viral
This-
fever, my
Mr.
lord.
25th July, this was adjourned already.
Yes, my lord,
This-
now
don't,
he affected
we
to-
don't need your assistance. This is a public interest litigation. We will permit you to retire.
I'm
No
sorry,
need.
ma'am.
Once the cognizance has been taken, your role is this thing. Don't seek adjournment in public interest litigation. It's not your
I'm
cause.
sorry, ma'am.
Sit down. Yes, Mr.
Lord,
What measure has been taken?
Lord, the amicus was appointed by my lords. She filed, presented.
She is not here.
She filed the report. Lord, report.
Where is that report?
Where is
Report, Lord, the report is filed on. Lord, the 13th December 2021.
13 this
30 December 2021.
13 1 3 30
Reason.
December 21.
Yes.
What is said in the
Lord, the elaborate law is, Lord, they brought to the notice of my lords.
No, no.
Assistance.
not law, Mister? What measures have you taken to save
Lord,
the
pursuant
crop?
to this, Lord, the amicus report, my lords directed to
Madam,
file
there is-
additional counter, Lord.
It is not put up.
My lords, after going through the amicus report, Lord, directed the forest department to file the additional counter. What are the?
You have all filed.
We filed the counter,
Yes.
Lord, the state government has, Lord, the, already there is a.
So where is 38/12/21 order, Mister? Sit down, Mister. You don't know anything. Sit down. It's our cause. We will decide. Where is the report, Mister? We don't have. You have a copy.
Me, I have the.
Oh, not given to court to you.
I'm the, Lord, the respondent forest department, Lord. Amicus report is served upon us. The copies.
Yeah, of course, we say something in good humor, right? We understand that it's shared with us also. You may have been given a copy.
54433.
It's not with us.
2021. SR number. I do not know. We don't have that report. It's quite huge, but bulky.
Last time he sought adjournment. Just now we told him, no? We did not go through the report. He sought an adjournment. So that's why we have refused adjournment today. Yes. Now this is, yes.
May same Lord.
1 minute. Please give us some time to go through this. We'll hear you. This, Mr. Do you know this monkey thing I had dealt with PIL? Karnataka High Court also we have passed some order. So why we insist for that, this thing is that sitting here, I should not contradict the view I have taken.
But the left amicus also brought the notice of my lords, all the judicial pronouncements by the Honorable Supreme Court. My lord, that can be found at my lord. Annex Z.
Rahul,
nobody.
No, Rahul, call Rahul. Lockler.
Okay. See, today nobody is there.
Call Amicus. Where is she?
Her name is not printed in the list.
If you can, anybody can contact her, please. All right. So what have you done? All
Lord,
these measures.
Lord, the
Have you, have you consulted experts?
Lord, pursuant to my lord's direction, we filed
Which
additional
order?
counter. Lord, additional,
Which order?
additional counter. Lord, 26th August, April
1 minute.
2022. Lord.
One. So you should contact my chamber, right? You have the number of chamber, chamber in Karnataka, and
Wonderful.
I told you that we have told you the period of 3 months from 30th July to October. In between these 3 months, as acting chief justice. So which is the order by which you are asked to file an additional?
Lord, my additional counter, Lord.
No, other order asking you to file additional counter, then we go to.
30th December 2021.
30th.
13th December 2021.
Where is your additional counter?
Additional counter, Lord, April 2022, madam. April 2022, Lord. Date.
April 22.
22. Date, Lord.
28th April.
April 2022. Date is, Lord.
28/4.
Yes, madam.
Counter affidavit it says.
Yes.
Additional.
Yes.
Yes.
Page number 3, my lord. The state, my lord, they have undertaken the, my lord, the Palle Prakriti Vanam. Lord, the plantation of the wild fruits, my lord, to feed the monkeys, my lord. Permit. Further, it is submitted that the forest department is regularly doing afforestation works and putting efforts and raising various sites of the plantation yearly with the available funds and to improve the existing green cover for the existing wildlife and to drive the monkeys moving in the urban areas to the nearby forest. The following important activities are taken up in Khammam districts by the forest department as well as the other departments with guidance of the forest department. Palle Prakriti Vanam. Palle Prakriti Vanam, avenue plantation, plantations in encroachment retrieval areas, crop plantations, soil moisture works such as the construction of percolation tanks, check dams, and saucer pits, establishment of the solar bore wells, monkey food ports. Palle Prakriti Vanam. It is submitted that in every Gram Panchayat, 589 Gram Panchayat and 165 habitations of Khammam districts, Palle Prakriti Vanam with an area of minimum 1 acre were developed and fruit bearing plants are planted to attract the monkeys into the nearby forest in future.
What is it? What is ex gratia compensation you are?
That is not the as per the GO 90 of 20.
Amount.
That the quantum is.
How much amount? Is there any fixed amount?
Page number 8, Lord.
So, Mr. All this we have understood that these measures you have taken.
Yes.
What is the effect on ground level?
Ground level, Lord.
You could be able to support this action taken with the statistics that the menace has come down, the monkeys have gone to the forest.
But after urbanization, my fair submission, Telangana state has taken the nursery in every village, providing the tractor and water facility.
No.
The burden is.
So with reference to these measures, right?
Yes.
And they should, like you have this thing, develop gardens and this thing, every village also you have done it. But all these guidelines must have the action taken should have some result, right? And that you should be that these measures have worked. Saying on paper we have done it.
Now
right?
we have
just a minute. Saying on paper that we have done it and its implementation at the ground level are two different things.
Yes.
What efforts you have made, how they have helped in reducing the problem, that you should be able to support by statistics or something. That so many monkeys, right, in these villages, the forests have been seen, their population has increased, whatever. What is the actual?
Not wildlife experts, my lord, we will take the wildlife expert and who has exercised in the.
Therefore, first of all, I mean, this you have you roped in the expert bodies to study the problem as mentioned in the report of the learned amicus.
Like the forest department, we are having we are also implemented.
Which expert bodies?
Well, the wildlife curators all.
Have you consulted them?
That
doesn't say so.
It's online.
Yeah.
Amicus is appearing in video call.
Yes. Yes, we will hear. So,
my lords, if my lords.
Key census, identify all these
technically, my lord, the experts has to come
So
with some
this
scientific.
In additional counter, you have said that you have taken some measures, right? So what we would like to understand is that what is, you should give us statistics, to say that how it has really helped in reducing the menace on the next date. Secondly is you have to, yes, madam, we'll hear you. You have to take steps for this thing, measures suggested by the learned amicus. So that directions will follow. The order will be, you please inquire from the court officer, because we are not dictating, it will take time. We'll do it in the lunch recess, that order will be available. So please obtain a copy and comply with those directions. There will be certain directions. Yes, madam. So we are asking them to, thank you for your comprehensive report. We will, this thing we are asking the government to implement the measures suggested by you, right?
Yes, your lordship.
Yes, we take it on record, your report, and then ask them. So there will be directions. Essentially, as we told that we will note down the measures taken by you. What is its impact on the ground level? Secondly, what all you have, this thing, the measures recommended by this thing, we will grant you 3 weeks time to come up with this measures, right?
Instead of 3 weeks, my lord,
4
we
weeks.
have it.
4 weeks, right? The order will follow. Just to save time, we'll pass an order directions. It's not being disposed of. Directions during this thing. Keep, madam, this file on my table just now. So I'll dictate the directions and make a copy available to them. You will be here, right? Later half.
I will.
So she will hand over a copy of directions to you.
Items 25 and 26 are connected matters with this PIL. They may be taken up independently.
Which?
It arises out of this. Item 25 and 26, they are clubbed with this.
What is the subject matter?
Subject matter is regarding the monkey menace, but in the city of Hyderabad, my lord, the petitioners have suppressed the fact that a statutory notice was issued to them under the GHMC Act for encroaching the balconies. They have erected iron grills, my lord.
No.
What do you expect? If monkeys are there, how do you expect them to protect their belongings which are on the balcony?
They have suppressed the fact that the other petition pending, in fact, regarding the.
That is true. But how can be so insensitive to saying that in order to protect their household items, if somebody erects something, you issue a notice saying that it is invalid, illegal?
No, my lord. The steps taken in that case, my lord, have been.
We are granting them time to take measures, right? The broad issue is not issue. Don't be interested in this thing, demolishing the grills.
No, not the grills. Not regarding the grills. In fact, it has become infrastructure. The flats,
there are better things to do. Very often we come across the petition saying that despite representation being made, you are not taking action for demolition of an illegal construction or not taking action for removal of an encroachment. Better things to do, much better things. It comes up, it's a common order in all the petitions. 3 weeks. This order is being passed in that case. It will be in this thing only. He has understood, right? Yes. They have to take measures. The broader issue is monkey menace, not the grills put by the.
GHMC also placed certain report, my lord. They have also placed some automatic traps. The report was also before your lordship in this writ petition, my lord. Your lordship may consider.
Which, madam? Yes.
Item
Which
20.
case?
Item 26, my lord.
26 report. His report you flagged.
Yes.
We will take a note of that. You have taken some measures.
Yes, my lord. Measures taken within GHMC limits.
All right. The government
in fact,
can
it has
also
become infrastructure since the Flat Owners Association have addressed a letter. That is, there is no menace at all. In fact, they were the complainants. In that
we don't know. It's too early for me to say that no monkeys in Hyderabad.
No,
too early for me.
With this PIL,
let me
can be taken
spend some time here, then I will find out, and from my experience will tell you. Right? Nothing is happening. No adverse order against you. These are all not adversarial litigations in that sense, right? Please. His case. Earlier case. 26. Put this item 26, amicus report put a flag, give it to me.
Same, along with that one.
Along. Yes. Next, madam. Yes.
I deeply apologize for the inconvenience, Your Lordship.
No, no, it's all right, madam. Yes, your name has not been mentioned. We understand.
Yes, Your Lordship. I deeply apologize, Your Lordship. I'll do my best
You will say
endeavors to assist the
This is
court, Your
directed
Lordship.
to reflect her name in the as amicus, right? Not that order. Other this reporters. Is this. We got the direction. Monkeys, death of monkeys. Mister, yes. Consider framing of a SOP, standard operating procedure, for capturing the monkeys and relocating them to a location, right? That's why we are telling you. That's why learned amicus has said that you should take it. This also, madam, keep it there. Yes, 27.
May I please?
Yes.
This is a case where contracts have been awarded in favor of RP without even calling for tenders by your order.
You wanted to file a reply affidavit?
Yes, madam, that has already been filed.
When? Who appears for respondents?
Appearing for agreement. I am aggrieved in this case.
You are relying on a judgment, right?
The contract is already completed, my lord. Project is handed over to them. Already people are occupying it. It is the project concerned is construction of home, dwellings for homeless persons. Project is completed, my lord, by respondent number 3. We handed over in the month of October 2022, and already people started occupying it. Now it is only at the stage of disbursement amount of the money. My lord, petition is filed, and this is a third PIL, my lord. Earlier 2 PILs were dismissed against same subject matter.
Payment is 50 crores.
Ninth August, we take it, Mr.
My lord, since there is an interim order.
That's why 9th August.
My lord, I will leave it to your lordships, but your lordship
9th August.
Squarely covered by your lordship's judgment.
We have
Paragraph
that.
13.
In fact, there are two aspects of the matter, Lord.
Mr.
Not only about
today and next Wednesday. What we are saying is today we have a loaded board. In fact, we did not have this facility as of yesterday to see how
many cases we are doing. So now we are rationalizing the listing. So I mean, we can assure you that 9th August it would definitely be heard. Mr. I'm ready. Why don't you prepare a short synopsis and do it, Mr. List-wise date to cut short time. He will tell us what this petitioner was born in the year 1949. It is a remote place in this thing.
There are two aspects in it. One is not only
lighter vein, Mr. So this all to save time.
Please answer his grievance, my lord. His only grievance is that
you should help the court with quickly this thing. You should ensure that we are not dependent on him for narration of facts.
I'll answer all this contention.
Not answer.
And answer. Very well. Well, I prepared
2 pages.
He should know how to save the time and money.
Brother has something to say.
Mr. Govind Reddy, you being from Bharat law, you should know how to save the time of the court. Where in US and UK, time slots are allotted to address the court within the time frame.
Yes, sir.
That's why you will help us conclude this matter in 15 minutes, right? So we can tell him that after having gone through your 2-page note, we will ask him straightway submissions. He will say 1, 3, 4, 5, 6, end of the matter.
Yes.
In this hope, we are adjourning it to 9th August.
Okay.
Please do it. List on mark pleadings in the case are complete. List on 9th August 23.
I may be permitted to appear in this matter. Lordships had adjourned the matter to today
My lords, the PIL was filed by the petitioner. The last occasion I had shown my credentials, my lord, the petitioner's credentials.
Why to the adjourn? There's some
The last occasion it was only for considering that
connected matter.
that connected matter.
Yes,
also
some lawyer made a submission already pending, right? Another pill.
Yes.
I'm appearing in 29, your lordship.
Next 29.
29.
29. I'm appearing for the petitioner. The matter is pending. The unofficial respondents are supposed to be filing their counters.
Where is that matter? Connected matter? Just one.
Yes.
Let us see the order sheet. It has been entertained that.
My lord. My lord, in item number 29, my lord, I'm appearing for the unofficial respondent, my lord. Respondent number 9. Lordship may kindly grant 2 weeks time, my lord.
So you have been granted 4 weeks time.
My lord, now the company, my lord, it's undergoing CIRP process, my lord. So,
Taking time for filing counter.
my lord,
All right. Heard learned senior counsel, item number 28. Heard marked everybody his presence, heard on the question of admission from perusal of order dated 23/2/20, from perusal of records of WP pill number 81/2021. It is evident that the similar issue has already been raised in the aforesaid public interest litigation. In the said rate petition, the said PIL 81/2021 has already been WP so and so. 81 has already been entertained, and time has been granted to respondents to file counter. Paragraph. In view of aforesaid, with a view to maintain parity, issue notice in this petition as well to respondents. Then item 29, learned counsel for respondent, Mr. You have to also file counter.
Counter is already written.
Right.
Already filed, that's been written. I'll read.
Learned counsel for respondents 9 and 10. So you see.
Counter was not filed, your lordship. Just filed a petition which was.
What can be done? They don't want to file. They are satisfied with whatever they filed.
Never mind. Keep it for final hearing. We'll
One case. This is a public interest litigation. The land will not be allotted to you if it is allowed. The undue haste indicates something else, right?
Yes.
That you are after the company which is being wound up. Shall we understand, Mr. That's why this person, since there was a delay, so in this thing 28, no, 28 you write, madam, after the issue notice. However, the all questions including the question with regard to delay and maintainability of the writ petition is kept open to be addressed at the appropriate stage. So you will not get the land, Mr. if this petition is allowed. What do you think? We are telling the council through video conferencing.
No, lordship, we are not expecting the land. It could be our council because it is very much the Rangareddy district code.
We don't know.
It can be used for chambers of.
You will have to let them file counsel. Then this thing. This case you accept notice 28. Which case? 28 is what, Mr.
38, my lord.
Which respondent?
7th respondent, my lord.
So 28, Madam, Mr. So and so accepts notice on behalf of respondent number 7. Learned
5th respondent.
5th respondent. Counsel for 5th and 7th respondent. Pray. You are also there. Which respondent?
3 and 4.
3 and 4 accepts notice 3, 4, 5 and 7. These people pray for and are granted 3 weeks time to enable them to file counter, issue notice to unserved respondents, unrepresented respondents. Then no, fine, no problem. But we are issuing notice. What else? Then you want a stay.
The company is undergoing CRP.
No.
You liquidated in favor of 10th respondent, Mr. Chandrasekhar. You have liquidated this land in favor of the 10th respondent. 10th respondent is constructing flats who will create third party interest.
All right, yes. In the meanwhile, it is directed that no third party interest in respect of the property which is subject matter of this petition shall be created by by anyone, including you also. Who knows? When he files a writ petition, Mr. Reddy, then so far I have this thing. So he will file a writ petition challenging the sale deed executed by you as null and void. Don't you find it interesting? Like in a writ petitions here, declaration is sought, sale deed is null and void. Something. No. Something unique about this court, right? So, all right.
The Lordship may kindly give a date.
4 weeks.
Lordship may kindly give a date.
No. We have to be more cautious, right? While dealing with the claim pertaining to title and this thing, all sorts of declaration, perhaps all city civil court should be abolished. All the judges should be High Court. Yes, madam. 2-3 more cases. Aye.
Obliged.
Lordship may kindly give a date.
We'll give a date. Don't have it. There is a stay now. Be happy. Let them first respond.
Grateful,
Yes. Longer date, 29th of August. For that matter.
Which case?
That Chandrasekhar's matter, 29th August.
29th August. 29th August. Mr. Your case. 29th August 23. Both the matters. Yes. 30, 31 and 30.
Go together.
What stay?
Hearing, pleadings are complete.
Okay.
The Lordship wanted a small note.
Yes. What has happened? What is the issue? What is the order and the challenge?
It's in the order passed in section 8 of the Arbitral Conciliation Act. Just one page of dates, but not that took very few pages.
Yes. So, can we take it up at the end of motion hearing cases after we finish?
Whatever you
Yes. We'll try to take it up to date since you all. Please wait later half. Next case, Madam, pass over. This will be called at the end of motion hearing, right? So others do not wait. Please, next case. Yes. 35. Yes. Madam, Vivek Jain, yes, 35. We should start calling cases. Pass over. Next. 36.
Madam, item 36, I'm appearing for GHMC, my lord. They're seeking 2 weeks time for filing additional counter.
This is contempt, right?
Yes, my lord. We have already seized the premises, my lord. Subsequent events have been taken.
No, you can get time to file compliance report.
Yes. We have already complied. Along with additional countermeasures, text.
File a compliance report.
Yes. 2 weeks.
That will grant them.
Yes.
Learned counsel for?
Respondent GHMC.
Which respondent? Sole?
My colleague has just left, my lord, after the bell. He carries it.
This is a contempt petition. The GHMC is not a party here.
Yes, my independent capacity, my lord.
Which you are representing who? The commissioner?
You don't have copy.
Yes, my lord. My colleague has just left after the bell, my lord.
Show him.
105 received counter.
Show him, he doesn't know for whom he is appearing. That's the irony. What can be done?
My colleague has left. In fact,
we can sit for 5 minutes later or
first respondent
for a longer time.
First respondent, the commissioner.
Counsel for respondent 1 and 5.
Yes.
1 and 5. praise fund is granted, how much time? 2 weeks time to enable it to.
But I am for report number 1.
Well, so nobody will be there.
We'll have to keep it faster and whatever it is.
Violation of law. This is contempt, right?
Yes, my lord, I am for respond number 1, 2 and 3.
We can't take it up now. He is not expected to be here past law. Then let it be. Remaining cases.
These are all old matters.
Old.
which are-
Okay. We'll take it.
Next one first, we have conflicted the law. Dates are not given or something that is like.
The Lordships kindly, may I make a mention?
We
Your
are
Lordship?
coming back. What? You want a listing tomorrow?
No, Your
Then-
Lordship. I just wanted a adjournment in a matter.
That how could.
I'll-
Who, anybody for respondents?
I've informed them, Your Lordship, there is a connected matters that is not tagged along with it. I'll
Which number?
74 and 90, Your Lordship.
It will,
I'll.
we assure you that we will take it up and then only rise, right?
I'm obliged.
Pass over.
Yes, madam. Proceed.
Whichever pass
Faster.
over.
My.
12
and 13.
Yes, sir, that's the case.
Yes.
What happened?
I have asked the management.
Yes.
They've agreed.
Agreed.
They've agreed.
They have
Only
Okay.
ensure
Well,
Milords, that an observation is made.
Yes,
Sub-
madam.
subject
there
to
is-
the.
Okay.
Milord.
So, should we record your submission?
Milord,
His submission.
Yes, my lord, my lords may record my submission.
In peculiar facts, he stated.
10 and 11 of the AB Education Act, my lord. A duty is cast upon the DUO to see that every child attends the school every day. And also the duty is cast upon
That is
the
not
parent.
Not on merits.
We are
Senior
not
counsel.
to merits. There is a
Subject-
concession made by the school. Let us take it and
Yes,
be done with it.
Yeah, be done with it.
The statement
Only thing,
Shall we record his presence or you
Well,
want your statement?
subject to he is following
No,
the
no.
rules and regulations.
Yes,
your lordship may say that
peculiar facts.
in the peculiar facts as a one time, the school gives a concession that he should.
When a query was put to learned counsel for the appellant, he fairly stated that in peculiar facts of the case, as a one-time measure, in case the student the one-time measure, the student shall be admitted to class 4. Admitted to class 4. We full stop. According in view of aforesaid fair submission made on behalf of the school, it is directed that the student shall be promoted to class 4 in which whatever school in the school and shall be permitted to prosecute his studies. We may hasten to clarify that this direction shall not be treated as a precedent as the same is based on the concession which has been given by learned counsel for the appellant in the peculiar facts of the case. Accordingly, this thing, correct?
Okay.
Thank you, Mr. Ravichandran.
All my lords, we are all.
We were anxious about this young boy.
Yes. In fact, he
He
himself
also.
is a
Thank
great
you.
helper, my lord.
Thank
I have
you.
always known him as one
Thank you,
who stands
Mr.
up.
Thank you.
It's
Thank you.
always been one like.
This question of law has been answered in your favor, right? And this you say that this constitution bench has not been further clarified or something, right? Correct?
Yes.
Yes.
Maybe. Lord, may I request Lords to take up IA2 of 2021. So we are seeking some modification of the earlier order.
Proceed with construction activity.
May I pass on some dates, events for Lords' consideration?
May I submit one?
Yes.
In fact, the very writ appeal was in fact, my lord's arguments were opened and we were submitting the arguments. Actually, what has happened?
I know that my advocate general wants the matter to be heard. In fact, my 2 applications are for.
So was it being heard?
No, IA2 is for a modification.
No, correct. Is he correct in saying that this appeal was being heard finally?
It was being listed for hearing.
It was listed for hearing. We have opened the arguments. The learned, my lord, the 4 learned senior counsel have appeared earlier.
I'll just submit to Lords whatever. Yes, sir.
So, senior counsel, we propose to hear it finally. We are giving you 3 dates: 14th August, 17th August, 18th August. Choose any one of them. And if it's not taken up, then perhaps we will pass orders on your IA.
We have it on 14th August, Milord.
But with this thing that you conclude that it will be concluded
I
on.
take, Milord,
half an hour. My lord, they are the appellants. Therefore, as a reply, I will take half an hour.
Yes, yes.
That's it.
My lord, Mr. Advocate General, ask your colleagues to prepare a brief synopsis, facts, etc., everything.
My lord,
So that we save time on that.
From my side, I prepared the synopsis and also dates and events. What I passed on to lordships.
It should be half an hour.
Not even
your experience at the bar, 10 minutes.
My lord, it has a long history from 68. Therefore,
That's why you have done well to this thing. Capture it for us.
But as far as this case is concerned, my lord, your lordship take 1 minute itself.
Very fine.
I am grateful, my lord, that if it is 1 minute, I'll answer it in half a minute.
Taking into account the nature of controversy involved in this appeal, instead of filing, instead of passing any interlocutory order passed on IA 2 of 2015.
Yes, 21.
Permitting the 21 permitting the petitioners to proceed with the construction, we deem it appropriate to list the appeal itself, which is pending since 2015 for final hearing. List on 14/8/2023.
Lord, in
One,
case, Lord,
small, one second.
pilots.
You are appearing for the appellant.
Yes, appellant in one case, writ petitioner.
Both.
Jilla Parishad.
Jilla Parishad.
Yes.
Respondents are, who are the respondent state?
My
Some
lords,
of the respondents, what we have noticed is the state.
may I submit, my lords? There is
whatever these are no conflict of interest, but better.
There is no conflict of interest.
But you transpose them as appellants, right?
No. What is under challenge is the memo or circular that is issued by the government.
The right exercised by the government is pursuant to a statute.
No, true, but
my lords, there are several
conflicting for Advocate General who is represented to argue against.
My lord, there are several writ petitions filed by the collectors against the orders passed by the CCLA.
Yes, it's all right. So please consider this aspect.
My lords, in fact, I have picked, my lord, from DD Basu, the power of Attorney General for India and the
That's the only thing. Yes,
it is in the, my lords. After all, we are fighting for
this. Probably this was on the last date of hearing. You are aware about it. Fine.
Yes, my lords. In fact, earlier also this was, my lords, debated on the bench. The learned division bench was pleased to go ahead with the submissions. Earlier, Advocate Generals have appeared in the act.
Okay.
That is very interesting. We are assisting your lordships.
Yes.
After all, we are assisting your lordships. Very interesting administrative law.
The object was to put this aspect because probably this submission was made when you were not there.
Yes.
It has come up last date of hearing.
That's also I have submissions and also the law.
Fine.
My lord, I'll just place that, my lord, for academic purpose, but that really is not a serious issue. Applies.
So we adhere to your time limit of 1 minute.
My lords, for me, I'll just explain. For your lordships to arrive at a decision, it will take 1 minute.
Okay. Yes. Subject to what all you say.
Yes, my lords.
All right.
I beg to represent Vivek Jan.
This what matter?
35.
No, this was previous one was 34. 35, yes.
I beg to represent.
None for petitioner even when matter is called in.
My lords, I'm sorry. I'm for the petitioner. I beg to represent Vivek Jain. This petition is filed seeking the inaction of the respondents 1 and 3 in not providing any remedy for the persons like petitioners who want to declare themselves as insolvent. My lords, in this counters have been filed by few people and respondents 4, 8, 9, 10, 11 people have not filed. My lords, the facts are like this. The petitioner has availed the loan to the extent of 3.25 crores, have repaid 1.50 CR. Now, my lords, I want to declare myself as insolvent. When I go before Debt Recovery Tribunal under the new code of 2016, they said that code, insofar as individual persons is concerned.
That has been repeated.
IBC doesn't provide for part 3 doesn't provide.
My lords, law is enacted, but that is not yet enforced by the Union of India.
No, but in the what do they say? Union say?
They say that it is our policy decision. So it is our discretion when to enforce it.
Counter is filed by.
Counter is filed by respondent 1 and 2. That notification, Gazette is not notified implementing the law.
I will consider
Section 96 or something.
Yes, my lord, from 96.
Section 96 not notified.
Not notified, my lord. Insofar as personal individuals like me are concerned.
Who appears for Union of India? What to do? Mark his presence, none for no grievance in this petition. Mark the presence, none for R1. The petitioner is an individual who had taken a loan from the bank and has not repaid the same. In this petition, the grievance of the petitioner is that no forum is prescribed in law to him to seek a declaration that he has been adjudged insolvent. He has become insolvent. Learned counsel for the petitioner submits that that section 96 of the IBC Indian Bankruptcy Code, the Indian Insolvency and Bankruptcy Code 2016, section 96 has not been given effect to. Full stop. In the absence of DSGI, hearing is deferred. List after 3 weeks.
I'm sorry, my lord, it is chapter 3. It starts from section 94.
Chapter 3 of IBC has not been given effect to.
Yes, my lord.
Right. No time today, right? Be fast. We are at 35.
Yes, no. Interim orders are dealt with 31, my lords. 31st, 31-8. Interim order is in my favor. Interim order is granted by the earlier division bench, which are
not to
extended.
recover anything from you. What interim order?
Not to take coercive steps, my lord. Because the division bench.
Coercive, you don't have anything. What coercive steps? The state of Telangana is a very good host. The occasion arises. They are extremely Mr. You are good hosts, right? What interim order? We don't know.
Interim order background is extended till the next date of hearing.
You don't have anything, right? You don't have anything.
You want you to be declared as insolvent. What will they recover? Where will they recover?
So let them at least initiate, right? Don't get a blanket sort of a stay. Come with a cause of action that now they have proceeded, they are taking coercive steps, sending me to jail.
Yes, may I make one submission? No. They are initiating proceedings against me.
No.
All across the country, they are
let them
initiating proceedings, my lord. When I went to
we will grant you the liberty to file an application seeking interim order.
It is already there, my lord.
The interim order has come to an end by flux of time.
No,
on 31st July 2022. Learned counsel for the petitioner, however, is granted the liberty to make a fresh application seeking interim relief.
I'm sorry, my lords. It is still 31/8/2023. Last time, Honorable Division Bench 2 has extended it.
And why are you saying that we are not doing anything?
Yes.
Why are you? It's already there, right?
Yes, ma'am.
So what do you want us to? What can be extended? The only thing which is expiring, it's already in force. Delete everything. Not everything. This interim order part. So why should you tell us?
I'm just putting before this court that interim orders are there in my favor.
Interim order is there up to 31st.
Yes.
So
yes.
we are giving 30th August.
Yes. Oblige, my lord.
Sure. Yes.
Milord, I beg to represent Angangul Anjay, Milord.
It's a contempt case, Milord. We have already filed a counter and a
What
complaints report.
Complied,
Milord.
Milord, we had given a reply to the counter, Milord. Actually, our concern is
not complied or not.
Complied, Milord.
Then what survives? This petition has been filed. This contempt petition has been filed, alleging non-compliance of the directions contained in the order dated 27/2/2022, passed in WP 231/2018. Admittedly, the admittedly, the aforesaid directions contained in the order dated 17/2/2022 have been complied with. Therefore, we are not inclined to proceed further with this contempt petition. Accordingly, the proceedings are dropped. Yes.
My lord, there is an application of continuation of delay.
Petition under 8 allowed. This all settled, right? Judgment, subsequent chloro controls and all that. Subsequent chloro controls has also been explained.
The matter is very short and simple.
So we will, not today. You know the long list.
My lords, as a matter of fact,
This or this or
September. Such a number. So shall we hear on 22nd August?
it's very. As a matter of fact, my lord, chloro controls has no application.
We will hear you on this, right? Prepare a short note on facts, half a page, and cite the case law. That's it.
I will not take more than 10 minutes of your lordship.
Yes, correct. This mark the presence in this petition, comma, the petition has asserted the validity of the order dated 24/6/2022, passed by the commercial court, by which petition under section 8
Section 8 of the Arbitration
of the Arbitration Conciliation Act 1996 has been allowed.
My lord, kindly condone the delay, my lord.
Oh, how much delay?
For
Madam,
resubmission.
yes, right. IA so and so. Delay condoned IA 1 of 23. Delay in representation allowed. Then see so and so. List on which date? We are giving 22nd August 2023.
My lords, I beg to appear for the petitioner here in the. My lords, this is regarding an order against the sole arbitrator. The only one important point I'd like to bring to this court's notice is the respondent on 12/6/23 has undertaken to file wakalat and countermand.
It's a communication, right?
Yes, my lords. The arbitrator, sole arbitrator changed his order after 3 months, my lords.
This whatever you are challenging is at page 7, right?
Yes, my lords.
What is that?
My lords, if my lords, my lords, I would like to bring to the senior advocate will be arguing this matter, my lords. I would just like to bring to the notice that respondent has not been appearing after giving undertaking for the last 3 hearings.
Not appearing today also.
Yes, my lords, which is
we are asking you what's your case. Best agent to tell us.
My difficulty, my lord, is the senior is engaged in this matter, so I would.
Even in the absence of any opposition, you are hesitant. That itself shows that lighter vein, Mister.
My lord.
Learned counsel for the petitioner. Mark his presence, none for respondent. Learned counsel for the petitioner. Prays for short accommodation to enable him prepare the case and argue the same. List on 24/8. Yes, Mr.
Revision is filed challenging the dismissal of the.
Yes, what are the grounds?
Grounds.
The restoration of suit, right?
Rejection of claim.
Rejection of
On the ground that.
Rejection of claim, order 7 goes ahead. He says.
Question of trademark.
There is
trade secret.
Where do you get this high value? Where do you get the concept of high value?
High value is
only high value. Huh?
Page 7 is the order.
Yes.
Ask them. Nothing, right?
Yes, okay.
Dictate.
What is wrong with the order?
Order, that is, the petition was filed for rejection of the plaint on the ground that trade secret. The plaint is totally with regard to trade secrets.
No. Raise all the grounds in the written statement. The court will frame issues, adjudicate it along with the suit. That's what we can say at this moment. Unless you want an order on merits.
One submission. As far as court cannot take cognizance, all commercial courts, jurisdictional issues have to be strictly construed.
It should go before another bench, right? list before a bench.
As far as
one of
juris-
us, so and so is not a member on Friday. What, 4th August? 4th August. 4th August.
This company is an NC and Yeah, no, there is no number. It's clear that
Okay.
I didn't see the parties.
Consider the type of liberty which we want to give you. Consider that also and argue. Next, 4th August.
Yes, should
Next-
not be an exercise in futility.
Only
Ultimate.
one judgment, my lord, I have.
No, Mr.
Nothing
What we have said that you didn't get the order.
No,
My Lord Justice Vinay Kumar has recused, so we have said that it would come in a different combination on 4th of August. Please do not argue. He has recused.
Very well. Yes.
You didn't hear.
1 second.
Yeah, I am
No,
clear.
1 second. I think there is a mistake. Please, please.
That it is 41 and to some wrong.
Oh, she has given a wrong file. That's why. No, the other thing you gave, right? That's why I was asking.
No, there is a mistake.
Mistake.
We took the other bundle, next bundle where I.
She has. Yes, go ahead. Order 7, Rule 11. Yes. Yes.
This revision has
Please.
been filed.
Ah.
Challenging dismissal of the petition under Order 7 to 11. The plaint has been filed for, the suit is for safeguarding the trade secrets, alleged trade secrets which have accrued to the plaintiff.
Nothing.
No, because I said, no, there will be this concept of high.
No. Again, that's why you say. Please go ahead, Mr.
Yes.
Please argue. No time.
Yes. The suit has been filed for
So,
protection of
this
alleged
thing,
trade secret.
this case also we are granting you at the outset the liberty, right? You can take all the pleas in this, in the written statement. The trial court will, the commercial court will frame issues and decide it along with this thing. So, this liberty, notwithstanding this order, afresh, this we can say, or you can argue on merits. If you don't accept this submission, first one, argue on merits. We will decide.
Argue on merits.
Please. So what?
The jurisdiction of commercial courts with regard to the case on hand is being questioned in this revision. That is the plaintiff.
What is the objection with regard to this thing? Why plaint should be rejected?
The suit
Which
is filed,
element of the suit says that it is barred under law?
I'll come. The suit is filed for protection of alleged trade secret, which has alleged accrued to the plaintiff over a period of time. So coming to the Commercial Courts Act special enactment for speedy disposal of certain cases under section
2C17.
2C17.
Please tell us.
Intellectual property rights relating to registered and unregistered trademarks, copyright, patent, design, domain names, geographical indications, and semiconductor integrated circuits. There is nothing regarding trade secrets, because trade secret is something which is not protected by any law.
1 second. What is intellectual property?
Intellectual property.
Does it not include trade secret?
It does not include, it is a species of intellectual property, but India being a signatory to TRIPS agreement, India being.
What is not provided specifically in law is not necessarily prohibited, right?
That's what
it should have said that note this thing, no suit, this, it will not be a commercial dispute, dispute pertaining to trade secret.
Yes.
It should have said so according to us. Yes.
So
What
then,
else?
as far as
We have understood trade secret, not a commercial dispute, therefore suit is liable to be dismissed.
yes, because trade secrets over a period of time, Indian courts have developed common law courts.
2-3 paragraphs. That's
Common
it.
law courts have developed a mechanism. Common law courts have developed a mechanism.
Yes. Please say. Yes. Please.
As far as trade secrets, it is a species of intellectual property rights, no doubt, but the definition is very inclusive. is not exhaustive. The Supreme Court in Ambalal Charabai's case held that all jurisdictional statutes must be strictly construed. Under the Commercial Courts Act, it came under Commercial Courts Act, where the question of immovable property being exclusive.
Any case law to say that trade secret dispute pertaining to trade secret is not a commercial.
That is why we need to understand what is the nature of trade secret.
No, we are asking you.
Trade secret, for example.
No, the case law is either, the answer is either yes or no. There is a decision of any court. Is it there or not
Yes.
there? Not there.
There are definitions. The courts have tried to understand what is a trade secret.
So there are decisions.
There are decisions.
Please
I'll,
say dispute pertaining to trade secret, not a commercial dispute. Which Supreme Court, which High Court has held so?
No High Court has held like that, but one Delhi High Court has given a vague statement that it has to be construed in a broad perspective. But the Supreme Court held that the jurisdictional statute, unless specifically conferred, cannot undertake to go into the aspect of, cannot take cognizance. That's what Ambalal Sarabai's judgment. I will read that.
Mr. Rangana, that statement itself debars you from filing a petition under Order 7, Rule 11, which matter need to be gone into in detail. From a reading of the plaintiff for Order 7, Rule 11 to file, it should be on the reading of the plaintiff, yes. It should appear to be barred by law. That requires a kind of investigation. It doesn't get barred. Simple reason.
That is the exactly mistake.
That's why we are giving you an opportunity.
Exactly the mistake done by the Commercial Court.
No, that's what I'm saying. You have to understand, somebody has to undertake an investigation. Yes, it will not come within the purview of Order 7.
The court should have conducted an investigation to see whether it is barred by any law or not.
We appreciate. Yeah.
So plaint has to be read. The court did not read the plaint.
Yes.
That is court.
Thank you.
Once we read the plaint, we come to know that.
We have heard, we are dictating the order. This revision petition is directed against the order of the Commercial Court dated 2nd June 2023, IVF 441 of 2022 and COS number 19 of 2022, whereby
Yes, next. 4th August, madam.
Madam, that item 41 will come on 4th August because I have to recuse myself in that matter. Yes.
I beg to appear on behalf of the counsel for the appellant. The present writ appeal is filed, agreed by the orders of the Lens Single Judge in allowing.
Nobody, they have been served.
I appear for official respondents, 3 to 5.
It's the,
What do you say that we should permit him to file an appeal, right? You
I was
want
not
leave-
made as a party, to the writ petition.
How are you this thing?
I am the one, on whose complaint.
Dispute between brothers. And what they say is electricity connections would not have, but electricity and water being a necessary distinct. Mere connection, you providing a connection would not confer any right.
May I please, one?
Mere provision of electricity, we have been taking a consistent view that mere provision of electricity or water connection will not determine your rights in this between the brothers, correct?
Very.
Do you have any title in respect of that? File a suit, seek a declaration against your brother.
My submission is that the suits are already pending between the my brother.
So
Suits are already pending. Now
they will say that this order shall have no impact on the suit pending between the parties. In any case, this order doesn't decide the rights of the parties.
May I just just draw your lordship's attention to the representation made by the the writ petitioner. He himself has stated that there is no power connection since 2 years.
True, Sunil, but understand one thing, we have been, this court has.
I know, my lord.
No, it's not that the power supply will be restored.
You, my lord,
Mr. It's not the case that if power supply is restored, he will avail of power supply and you will pay the bills. Not like this. So,
there was no connection, my lord. Now all of a sudden, my lord,
What happens to collect connection if it is provided? It doesn't affect your right. You will get the premises with electricity connection if you succeed in the suit.
In fact, I will tell you, there is power connection near my house to a tree.
Yeah.
It is. You see, your apprehension is by taking advantage of this connection, he may try to construct and all. I will tell you my own personal experience. There is a power connection outside the area where I live, which is fixed to a tree, neem tree. The meter is there. If you want, I can show the photographs after the hours.
Mark the presence. Mark the presence. This IA to leave.
I only clarify that.
Clarify. IAs are allowed. This thing leave petition and condone delay allowed. Dispense with also allowed. Like this intra-court appeal emanates from an order dated.
I apologize to interfere.
Emanates
Now, my lord, by
from an
virtue of the
order-
new connection, he will try to interfere with.
Emanate from an order Yes.
Great respect to sample for and in this case, I am
Counter to leave application. Yes, Mr. Prabhakar.
being a Adivasi activist,
No.
requesting this.
So they wanted. You don't appear, right, for respondents.
No, alternate prayer to.
Is appearing for respondents, my lord. 1, 2, 3.
Counter to leave application. I'm not saying whether he wants to file.
No, Prabhakar has to. No.
He has to file.
This turns
Respondents to file.
for respondent for counter to leave application.
In similar writ appeal, National Advocate General is being appeared.
Notice before admission has been issued. What is your grievance, Mr.? What happened?
Actually,
They don't want to do anything. Go ahead. Yes.
Lordships, before my land plan starts, I may permitted.
You not saying right? Anything. Don't waste time of the court. Say whatever. Don't look at us.
I am requesting time for filing count.
Say so. This is a writ appeal. Which provision permits, enables you to file counter in a writ appeal? We want to know.
Counter against the leave application and control.
That's what the time is granted. That's what I am showing.
In that area.
You are not saying. I told him that he is not saying that I want time to file counter. I told him like this only. Yesterday, Advocate General assured that you won't waste time of the court. 140 matters on board, and this is what it is. Learned counsel for respondent number
1, 2, 3.
1, 2, 3.
Lord, I appear for respondent number 1 and 2, Lord. I request time for seeking adjournment, my lord.
Better.
My lord, there is an amendment petition, my lord, filed by them, my lord, seeking to amend his prayer, my lord.
You are appellant, right?
I'm for respondent number 1 and 2, my lord.
1 and 2.
Yes, my lord.
Amendment petition is being filed.
You have filed.
I am the petitioner, I am the petitioner.
So when have you filed?
I filed
Not on record.
counter yet not filed.
What?
Counter
Learned counsel for respondent praise for is granted.
Yes, 2 weeks time, my lord.
1 week is already a local branch.
10 days time to enable him to file counter to the application for amendment filed on behalf of the petitioner.
Gopal, you are deciding his time to file counter.
So that's why we have found out via media today, no time.
Sir, Mara, I'm for the petition.
That's what he said, that
You are deciding time for him within how much time he has to file counter.
That's the second time they're taking time for the counter.
you must have seen para 7, 8 and 9 of their counter. That's why amendment, presumably.
Give you a blessing.
10 days, Mara.
10 days, what date, madam?
We have already given 3, so it will be about
14th August.
14th.
Right, please, lordships. On the last occasion, my lord.
Original record.
Yes, my lord, the ET was directed to produce it.
You have filed counter, whatever.
Counter is filed.
So this right, this all validity of provision dealt with by Supreme Court or doesn't?
No, those
1786 of PMLA, you should place on record the judgment. Your this thing client need not stand, Mister. In case he wants to argue, he is welcome. Then you retire.
As far as I am standing here, I will not allow that.
That's what.
Yes, sir.
We don't like people standing behind this thing.
He just wanted to help me to give papers, my lord. 5 cents.
So,
No, my
what
lord.
is this? 1786 not dealt with by Supreme Court?
Yes, the latest judgment in that aspect was that, my lord, the.
So, pleadings are complete, right?
Yes, yes, my lord. That is Vijay Madala's judgment was there, my lord.
We will go through the original record.
Yes, my lord.
Fix the date.
On 2 aspects, I was insisting last time, my lord, with your lordship.
Oh, it's coming up for the
Reason-
first time before this.
Sorry. Reasons, whether reasons are recorded or for the.
That's the order.
Yes, yes.
That's the order for
Yes,
that original
yes, yes,
record.
yes.
You produce it, it be kept in seal cover in compliance of the order dated 11/7/2023, learned GP, whatever. Whatever.
Standing council.
Standing council has produced the original record. The registrar should.
Bring for petitioner, my lord. I bring for petitioner.
What
do you want?
Your lordship requesting.
You are appearing for bank, right? Respondents in whose possession property? Who appears for the bank? Then why don't you take possession if the auction sale has been cancelled?
Negotiations are going on between the borrower and the
Happened, my lord. Property list of
Please sit down, mister. Sit down. We are unable to see.
My lord, in the public auction, my lord. After that, my lord, we consulted along with the apart.
Learned counsel for, so negotiations are on, right?
Yes, ma'am.
Huh?
I consulted.
No, negotiation is on with the bank. So therefore, learned counsel for the bank as well as learned counsel, Madam, right, in this petition, the grievance of the petitioner is about the inaction on the part of bank in not taking back the possession of the properties which were auctioned. Paragraph. When the matter was called today, learned counsel for bank and the auction purchaser submits that the auction was held in the year 2015. In the year 2015, and for instance, you are a defaulter. You are a defaulter.
Yes.
You are, why we should show indulgence? Please tell us on the next date of hearing why you are entitled to indulgence in exercise of extraordinary discretionary jurisdiction of this court.
This matter,
You are a defaulter.
this matter,
Taking a direction, which law says that, which law statutory provision says that after cancellation they should take possession? All this is nonsense, right? We'll dismiss it. Petition, be careful. Statutory right, conduct. Tell us whether you have paid. So submits that into negotiations, right? Learned counsel for the petitioner shall also apprise this court on the next date of hearing whether he has paid the
The sale Milord, the petitioner has given summary
No, no, it
representations
is-
to the bank Milord for settlement, but the bank has not considered our request Milord.
This too late. So therefore, this petition is not that simple, right? 28.8 public.
Lord, in this matter.
Again, same HRC. No.
First respondent or second respondent has sorry for lodging. Name was not reflected in the list for lodging.
Office is directed to reflect the name of Mr.
Second respondent was there.
Who appears for him?
Standing counsel for.
That's I'm appearing first HRC Milords. So papers not served on us Milords. Papers not served on us.
Papers not served.
Notices were sent, my lord, notices were served and the copies are deposited in the bundle.
1 second.
Yes, Milords, but we don't
So
have
cut
papers.
short,
Milords.
if you can survey copy, we will take it up.
No, so
The law on this aspect is very clear. Section 12 of HRC Act and the judgment of the Honorable Supreme Court in 2014, 15 SCC.
Yes, sir. Just now today itself we have dictated an order, madam. What you are doing all sorts of things, right? Deciding title, directing maintenance of status quo in respect of the properties, and this happens to be a matrimonial dispute there also.
Milords, actually my standing counsel name is not reflecting in the list Milords.
No, we are saying something to you beyond the copy.
Yes, yes, yes.
So think about it. What are you doing?
Registered the name of so and so appearing for the second respondent and list the matter. Counsel for the petitioner is directed to serve copy of the papers on learned counsel appearing
And
for the
what
second respondent and list the matter on we list it on
14th August.
so that it can be.
14th. R1 and R2.
Lord, in both these matters, may I request, my lord, we are relying on a judgment of Honorable Rajasthan High Court, my lord, wherein the notification of the NCTE was struck down. My lord, matter is carried to the Honorable Supreme Court, that it was reserved. And we are told, my lord, in the connected
Learned
matter.
counsel for the appellant, learned counsel for the petitioner submits that issue involved in this appeal.
We are told, my
no. So notification was challenged before this thing.
Rajasthan High Court, my lord.
Which notification? Same? No.
My lord, 26th, that is notification dated 28 June 2018.
28 June
2018.
Issued by
National Council for Teacher Education, NCTE. That was struck down, holding it badly. That was challenged.
Got it. Learned counsel for the petitioner submits that the notification dated 28/6/2018 was issued by National Council for Teacher Education, pursuant to which the impugned notification dated 24/3/2022 was issued by TACT, right? TSTET.
Yes, ma'am.
What is it? Whole form you write?
I'm sorry, my lord. It's 23rd March 2022.
23rd March 2022.
Yes, ma'am.
Right?
PO issued by the state.
Fine. Learned counsel for the petitioner submits that the notification dated 28/6/2018 issued by National Council for Teacher Education was challenged in a writ petition before the Rajasthan High Court, and the aforesaid notification dated 28/6/2018 was quashed by a division bench of the Rajasthan High Court by an order dated
I'm sorry. 25th November 2021.
25/11/2022 in 21 in WCWP number DBC WP number Do it. Next 50, madam.
May I please your lordship, I'm beg to represent on behalf of petitioner's counsel Arna. Your lordship, it's in a case.
Counter.
Lordship, in this matter, the Human Rights Commission passed an order.
Just now some council appeared, right?
Yes. Based on the.
See, madam, how active you commission is. Every case you are required to appear and defend. What have you done this time?
This matter also papers not, sir, my lords.
Order directing maintenance. See, Mr.
Based on empathy and equity.
No, we are like this matrimonial dispute, this thing, claim for maintenance, land disputes, everything Human Rights Commission will decide. We are very happy. So all these petitions we should refer to Human Rights Commission. What is this, madam? Manned by judicial officer? In this petition, the petitioner has assailed the validity of the order dated 8/10/2021 passed by the
Then this.
Brother is referring to some order, right? Please place it on record.
Amendment
We will
was challenged,
consider.
saying that we have our own bylaw. The central bylaw will not be applicable. The Bar Council of India directing us to, amend our
Please place
bylaw.
on record.
I will place that on record, but
Please place it on record. Learned Council for the parties jointly pray for adjournment in order to enable them to.
Two, the cooperation department is made as 40, but the society is registered in that society's registration act.
that is amendment,
The
I
revenue
have to ask you
department is
for
the
that.
concerned department, not the cooperation. The
I'll amend.
registered under
I'll
registration.
make an amendment.
In view of delete, mark the
First
presence,
petition respondent.
in view of submission made by Learned Council for respondent number 1 and 2, Learned Council for the petitioner, praise fund is granted a week's time to enable him to make, to implead necessary respondents by amending the cause title. Yes, next list thereafter.
List on, give it on 22nd.
22nd.
Deeply obliged.
Petitioner.
The respondent wanted to this matter.
Who is appearing for the petitioner? He is supposed to file a better affidavit.
Who? Petitioner?
Yes. Better affidavit.
Notice is not issued.
Application by the presentation given by the petitioner is not disposed of.
None for the petitioner. No. None for the petitioner. Let the none for the petitioner. We grant 2 weeks further time to enable the petitioner to file a better affidavit in the light of order dated 24/6/2022.
Challenging the new enactment, Act 29 of 2020, writ petition was filed. The alternative relief, my lord,
Which are for admission, we can do. Otherwise, we will statement. We will, they do not come in the rest. Wherever we are admitting, we will allow it. Wherever we are admitting, we are saying that we get the matter from the 3 weeks or 3 weeks, we give it special rules so that it, otherwise, we still doesn't have.
counter would be required on this matter.
Learned, special so and so, praise fund is granted
3 weeks.
4 weeks time to enable him to file count.
Right.
First week of September. September, 5th of September. In fact, it's a virus.
I admit.
We are admitting the matter because the challenge is to the virus of the.
4 weeks.
Alternative relief, my lord, which is sought for, is already
4 weeks.
addressed by the state.
None for the petitioner, record perused, admitted for hearing 4 weeks.
Right.
Right, please. Lord, this
There is nothing.
writ petition is filed, my lord, by the agreed parties, namely the artisans.
What is the prayer?
The prayer is challenging the guidelines which prohibit.
You want permission to immerse plaster of Paris idols in the lakes.
No, there can't be there can't be a ban on making and selling of the idols. It is not an environmental pollutant or water pollutant by itself. What they say is the colors that are used are toxic and they are pollutants. So there can be.
There is your
There is a there is a detailed order by this honorable court.
That's it.
I was a member to a order passed
Yes,
by this.
your lordship was the member.
That was carried to Honorable Supreme Court.
Yes.
In fact, Supreme Court confirmed it and granted some liberty to the state at that point of time for that particular year.
Particular year, my lords.
Particular year is the direction that you will wake up in advance for the next year, year after, thereafter. That was
But
the
all
order.
the guidelines of the PCB have also, I just have to some time, my lord, 1 week's time.
That is with regard to the immersion of the idols in the Hussain Sagar Lake, only that much.
Yes.
But this is, all these orders including your lordship's order, was considered by this honorable court in
Permission from the court and where you don't take your agreement. Who will get some people will go and innocent and give everybody one. Status created separate parts, main forms like Bangalore.
Wow.
They created.
Mr. So, like his grievance immersion not justified, but he says that how can you prohibit even manufacture? That's a question of his livelihood.
But the earlier division bench was pleased to hold that.
So please seek instructions. Will
No, there is an interim order already passed since liquidation on 21.
then be happy. Be happy. Interim order. Let him then file counter if there is an interim.
That got last year. We filed the counter. Both the DSMC and the Commissioner of Police have filed the counters, but they have not been able to controvert any of the grounds we have raised.
No, Mr. As we understand, your grievance is only with that you should be permitted to make plaster of Paris idols.
Yes.
Right?
Yes.
What is the prayer?
Prayer, my lord, is
To consider and dispose of representation.
no, not the dispose of the. We are challenging the guidelines.
No, please.
Okay.
One second.
May I submit, my lord? My lord,
Hey, Mr. This page 10. What I mean, either we are wrong or you are this thing. You have not read it. Page 10, prayer read aloud.
56.
We are taking up 56. You are addressing some in some other case.
Prayer
56.
10, page next.
50 appears for the petitioner.
I'm appearing in this 57 matter.
57, we have not yet solved. We are taking up 56.
56.
What is that?
Adjourn then.
But this is only for consideration
what
of
do you want?
representation.
That you will consider.
Yes.
We can dispose of.
Both are wrestling together, my lord.
Huh?
Both are wrestling together, 56 and 57 with regard.
Nobody
to
appears, right? For the
And what
petitioner.
my learned friend, my lord, challenges the.
No, that is
guidelines
separate
number
issue.
2, my lord.
None
And-
for the petitioner. Mark his presence, learned special GP. Awaiting appearance, hearing is deferred.
Right.
Petition, interim order for the last year. Because these people wanted to find.
No, let them respond, then we will consider the prayer after 2 weeks.
You lost me.
No, which you, he is appearing counsel, who are you? You want to oppose the prayer? So you respond to his prayer.
Yes.
You respond to his prayer. We will consider.
Where is your, you are not yet impleaded. You are not impleaded. Where, when?
One second.
No, not in our petition.
So we hear him, Mr. If the person has come before us saying that I should be heard, he should be heard, right? That order
I have
will
no
bind.
objection for hearing him.
Fine. No, he will argue first. So we are just giving you time. If we should we take it next week? Seventh is the earliest, 7th August.
7th August.
No, this is interim relief. Let the petition be listed for consideration of prayer for interim relief on.
So they will make use of Saturday, Sunday and Independence Day and.
So, 17th August. Brother says that you should make use of the Independence Day, Saturday, Sunday.
and Independence Day to file your counter.
We don't know whether anybody will, it's for you to utilize. 17th August. That's it.
May I please? This case also, my lord, the jurisdiction of the State Human Rights Commission entertaining, my lord, family dispute.
District one. Madam, where is she? In this writ petition, the petitioner has assailed the validity of the order dated 7/12/2021 passed by the Human Rights Commission.
Yes, ma'am. The council is there.
By which the petitioner stroke husband has been directed to appear in person before the State Human Rights Commission in a complaint in a matrimonial dispute. So in view of same order, right, section 12 of so and so, and as interpreted by What? In pertaining to Learned Counsel for Respond number 3, praise fund is granted 2 weeks time to enable him to file counter. 3 weeks praying for counter. Still next. This take these files. Counter why? Who?
This matter, my lord, I appear with the fifth respondent, I filed counter.
You have filed. I filed. Let counter if any on behalf of respondents want. Learned Counsel for Respondent number 5 undertakes to supply a copy of the counter filed on behalf of aforesaid respondent to Learned Counsel for the petitioner by tomorrow. Let counter if any on behalf of respondents 1 to 4 be filed within a period of 3 weeks. List thereof.
Same order.
My lord, I am representing on behalf of
HRC.
petitioner.
In this petition, the petitioner has
I'm
filed.
representing on behalf of petitioner, my lord.
In this petition, petitioner has filed the has questioned the order dated 21/7/2022 passed by the Telangana Human Rights Commission, by which what has been done, madam?
In the last adjournment, stay was passed by this honorable court, my lord.
Was constructed, so by which a Human Rights Commission has directed demolition of cattle shed constructed by the petitioner.
Yes, my lord.
Same order, section 12, interpreted by Honorable Supreme Court, prays for adjournment 14/8.
Much obliged, my lord.
Stone crusher.
In a stone crusher where the Gram Sabha passed a resolution not to give NOC, still they are in action.
Counter.
Counter has come, one counter has come from R6.
What about 1 to 5? Nobody appears. They- You are appearing for petitioner, right? 1 to 5, they don't want to file any counter.
District Industries Center.
This matter we filed, my lord, counter file.
Your counter is there?
Yes, my lord, file.
One second.
Pollution Control Board.
Yes, my lord. Pollution control counter file.
Got the copy.
No, my lords. I have filed my
One
counter.
for the petitioner, Learned Counsel for
Respond number 6.
and 2, Learned Counsel for 2 and 6 submit that they have filed counter awaiting appearance of petitioner, hearing deferred 2 weeks.
2 weeks, no, date is one.
Ah.
No. Yes, next.
But in this matter, senior counsel appearing there, Mr. Ashok Anand Kumar, he requested to next week. Just file.
File. You want to file any rejoinder?
But I have filed a rejoinder, my lord.
You have filed.
Yes, ma'am.
File logs.
Yes, my lord.
Pleadings in the case are complete. Petition is admitted for hearing.
List on 5th of September.
5th September.
It's the state's writ, Lord. Stay has been granted. No counter has been filed by the petitioner.
Human Rights Commission.
Yes, Lord. Stay has been granted, Lord.
So we'll have to.
This petition has been filed. Madam, where is she? This petition has been filed against an order dated 10/3/2022 passed by Telangana State Human Rights Commission, by which the government, municipal and electricity authorities have been directed to provide water and electricity facility to respondents therein. Same when a query was put so and so. Give some. Will matters on 1 day.
No, we can dispose it of things. 16. 16.
17th seems to be little.
All right. So when a query was put so and so, this thing section 12 Supreme Court prays for adjournment list on 17th August.
Please, your lordships.
Madam, generating litigation for this court, you want to equate yourself with the state, right?
And the instruction are in for.
Yes. 74.
My lords, I'm representing the petitioner.
Yes.
Lordship, there is a connect.
We told you, right?
Yes, your lordship.
Assurance.
Yes, your lordship.
Yeah.
I'm grateful.
Yes.
Lordship, there's a connected matter which has been directed, in fact, on 5 occasions earlier.
It has been issued.
No, your lordship, a connected notice was issued, your lordship. A connected matter was directed
As
to
prayed by learned counsel for the petitioner list along with WP number.
43016 of 2016.
Got it, Mr.
43610 of 2016.
Yes, your lordship.
On.
Which date? This is give it on 29th.
29th, madam. 29th.
No, I request for an earlier date, your lordship. This is actually pertaining to, your lordship, under a project, your lordship, lands were taken, your lordship, but the houses were not taken for acquisition, your lordship. And in fact, these people had approached the Lokayukta, your lordship. In the connected matter, your lordship, the government challenged the order of the Lokayukta and obtained a stay. They have not received compensation for the houses yet, your lordship.
22nd August. 22nd August. There are 70.
22nd August.
I'm obliged.
We really want to hear it, madam. That's why. You have seen what is happening today. The matters are coming fixed by other benches. So it's.
I understand.
That's why we don't want to do like this on the next date.
Matter, right?
In this petition, petitioner has assailed the validity of the order dated.
Madam, at page 28, order dated.
What is the order?
18/8/22 at page 20.
18/8/2022 passed by Telangana State Human Rights Commission, by which what has been done?
They have directed us to give them again electricity and labor law benefits, which has already been dismissed by this court.
By which petitioner has been directed to provide the
Power and water connections.
power and water connection to respondents in the complaint. This thing, learned counsel for the paragraph, learned counsel for the petitioner submits that that the grievance raised by respondents has already been adjudicated in a writ petition. Writ petition before this court, namely WP number
11417.
417 of 22, which has been dismissed on.
Came to be closed.
Which was closed on
17th August 2020.
17th August 2022. Then when the right query put to so and so 17th August better.
I think it is my order. We don't this. Property
This is Priyadarshini Spinning Mill employees.
property purchase from liquidation. Only
It is
land purchase.
Land.
Yes, 17th August. This is what 70. Yes. 76.
The challenge to Act 47.
Notice has been issued.
Third also, issue notice. Who is appearing for the petitioner?
None for parties. Let counter, if any, on behalf of respondents be filed within a period of 4 weeks.
September 4th. Yes.
No counter affidavit has been filed in this case.
Huh?
No counter has been filed by the second respondent.
This is
None
electricity board.
Mark the presence, none for respondents. Let counter, if any, on behalf of respondents be filed within a period of 4 weeks. Yes.
5th September. Next.
Counters not filed. Only requested 2 weeks time will file counters.
Learned counsel for what your GP, learned GP praise fund is granted 3 weeks time to enable him to file counter.
38.
79?
Yes.
Requesting 3 weeks time, filing counter, your lordship.
Learn it. What you are what GA?
AGP appearing for
AGP.
additional application.
3 weeks time.
Much.
Yeah, 24, 3 weeks. 24.
Yes, 80.
Okay.
No counter. None for parties. Let counter, if any, on behalf of respondents be filed within a further period of 4 weeks.
Represent Lakshmikant Lords in this matter.
Counter is awaited.
Yes, counter is awaited.
What? None for respondents. Let counter, if any, on behalf of respondents be filed within a period of 4 weeks.
I'm appearing for respondent. I'm appearing for respondent, enforcement director, file counter.
You have filed.
Maybe taken up any date.
Date, you don't want to file any rejoinder?
We'll file.
All right. You have filed.
We'll not file, but we will file.
How much time?
4 weeks.
Learned senior counsel for the petitioner press is granted 4 weeks time to enable him to file rejoinder.
Bring for first respondent.
Counter.
Earlier matter, reading matter was EMAR. Which are same, which are okay.
What order is under challenge, madam?
Record of HRC number 845 of 2021 minutes.
Sanitary inspection is responsible for
Record is here.
appearance of the sanitary inspector for.
As per the
This petition has been filed against an order dated 22/2/2021 passed by the Telangana Human Rights Commission, by which sanitary inspector has been directed, sanitary inspector of Kutbullapur, Hyderabad has been directed to appear in
the record.
Please, file records minutes.
Appear in person before the commission. Then query was put.
Jurisdiction, we are on jurisdiction.
Jurisdiction. Query was put, section 12, decision prays for adjournment to enable her to examine 17/8. Two very important dates for you, madam.
14 and
14 and August, 17th August.
These two matters pertain to FBBS admission. The interim order, the yet to file.
Not filing counter. Let counter, if any, on behalf of respondents be filed within a period of 3 weeks.
Right.
You should have said, madam, stand here. Not,
Yes, my lord.
Not
Next
this, we can't see you. You are not visible to us. These people stand.
2 weeks, sir.
2 weeks. Fine, yes, 2 weeks, 2 weeks.
Right.
Yes. 86.
Let counter, if any, on behalf of respondents be filed within a period of 4 weeks.
Next.
The petition counsel is JND service, Millard. No objection is to file, Millard. 2 weeks time. The petition counsel, Mr. Ravdeep, Millard. As JND services, Millard. Judicial service is JND. Got a job appointment.
Mr. So and so learned counsel praise warrant is granted 2 weeks time to enable him to prepare the case and argue the same. List after 2 weeks.
Next.
Coming for the counter.
Learned GP praise warrant is granted. GP for medical.
It's a
GP 3 weeks time to enable him to file counter.
Obliged.
Kindly taken up 3 weeks time, Millard is filing for who?
For whom you are appearing?
Services 3 law.
So and so services 3 praise warrant is granted 3 weeks time to enable him to file counter.
Yes, ma'am.
My lords, I'm appearing for respondent number 5 in this matter.
Yes.
My lords.
Yes.
Where are you?
I'm appearing for respondent number.
We are looking at this side.
I'm appearing for respondent number 5 in this matter, Your Lordship. We need to file a counter.
Learned
by
counsel
request for
for
4 weeks.
respondent number 5. Praise warrant is granted 4 weeks time to enable her to file rejoinder. Say none for
I'm
the
obliged.
petition. Counter.
I'm obliged.
Yes. Next.
Requesting.
I'm appearing for the petition. 3 weeks, Your Lordship. I'm appearing for the
Which
petition.
respondent, madam, say so.
Respondents.
1 and 2. Praise warrant is granted 3 weeks time to enable her to file counter.
My lord, 2 weeks might be sufficient. My lord, it's a 2 weeks.
We
might
don't
be
know. Don't. If she doesn't file again, she will seek time. Better no to wait for a while.
Obliged.
Yes, next, 92.
What?
Pollution control board. Pollution control board.
Let counter affidavit, if any, on behalf of respondents 2 and 3 be filed on or before next date of hearing. Telangana Pollution Control Board, Mister, tell them.
Yes,
They've been served. Yes. None for petitioner. Awaiting appearance, hearing deferred. List after 3 weeks. In the meanwhile, counter, if any, on behalf of 1 and 2 be filed. Yes, 3 has filed.
Yes. I am representing respondent's lordship, Y Ramarao, on behalf of counter filed today, lordship.
Today?
Yes.
You are appearing for?
Respondent number 17, 19 to 23, 25,
Counsel
28.
for respondent 17, 19.
17, 19 to 23,
23.
25 and 28.
28 submits that the counter has been filed today.
I am for the respondent number 9 and 12, madam.
Your
Respondent number 9 and 12 are filed counter.
State 9 and 12 states that counter has already been filed. Then office is directed to trace the counter filed on behalf of so and so 19. So, and you don't want to file counter. Trace the same and place it on record. List after 2 weeks. 95. No notice, interstate zonal transfer.
Maybe lordships. Maybe post after 2 weeks, my lordship. I'm for the petitioner.
Learned counsel for the petitioner prays for adjournment to enable him to prepare the case and argue the same list after 2 weeks.
Yes, ma'am.
In this matter, Lordship,
Huh?
I am for respondent number 2 to 5, your Lordship. I will file.
Learned counsel for respondent 2 to 5 praise fund is granted 2 weeks time.
4 weeks time.
4 weeks time to enable him to file a counter.
Much obliged.
File an complete petition, right? What
you don't do that. Direct the registry to remove the name of the GP for municipal administration, your Lordship.
Office is directed to reflect.
The name of general administration, GP for GAD, your general administration.
GP for GAD.
General administration.
Yes,
all.
Much obliged.
Yeah.
Delete so
Delete so and so.
delete so and so and print the name of GP for GAD.
Yes, madam.
My lord, this is a matter wherein the petitioner before, I'm here.
And for the respondent,
Yes.
Counter has been filed by R1.
Filed, my lord.
What about this thing, others? They only one respondent.
Only one respondent.
What is grievance, madam?
My lord, the petitioner has borrowed a sum of 5 lakhs.
Oh, by now we should know that you are only appear for.
No, I'm relying on the judgment of this honorable court, my lord. That's
What
on
is
page
the order
70.
under challenge? What is the order under challenge?
The
32
symbolic
notice.
position has been taken, my lord. Symbolic position of the petitioner's property has been taken. A similar matter
Applicable under 17.
A similar matter fell for the consideration of this honorable court, my lord, wherein the amount borrowed is less than 10 lakhs. Your lordship may kindly see page 74, my lords.
Appeal. All grounds can be urged in an appeal. This Mr. Madam Satyavati Tandon and subsequent decision of Supreme Court in 2022 prohibit the Supreme Court has deprecated this tendency, right? Involving devising new grounds by ingenuity and approaching this court will not help.
Yes,
So
if
we
I
have to
may,
follow.
if I may request
Please.
your lordship, my lords, no, since there's an interim order in my favor, your lordship may protect for 4 weeks. I'll take steps before the TRT, my lords.
Right. In this petition, the petitioner inter alia has assailed the validity of the notice issued to them under section 13 within bracket 2 of the SURFACE Act 2022. Paragraph admittedly against the aforesaid order, an appeal lies under section 17 of the Securitization Act, whole thing, right? SURFACE Act to the Debt Recovery Tribunal. Paragraph, learn it, full stop. And the Honorable Supreme Court in Satyavati Tandon, Madam, 2010, Volume 8 SCC. Get that orders, Madam SURFACE and all that, right? Here readily.
I'm
Citation.
appearing for 2 minutes.
You should be having
I'm appearing for the
counter.
I have already filed a vacate stay, my lords. Matter pertains to filed a vacate stay.
He has filed a vacate petition in a stay matter.
This is a case where Milord
state.
I'm appearing for the
Yes, petitioner. What is the stay in your favor?
Oh, it's a case Milord where the second respondent, that's a complainant Milord, approached the Lokayukta saying that her husband worked for some time under the petitioner.
Ramarao, we will hear it we will give a date and hear it on. Which one?
22nd or 23rd? Let so and so pending interlocutory mark their presence be listed for consideration on 22nd August.
Yes. Yes.
None. None for the petitioner, hearing deferred. List after 2 weeks. Don't give a date.
I'm appearing for the petitioner.
I'm
appearing for the first respondent. I'm appearing for the petitioner.
Lord, I'm appearing for 11th respondent. Lordship may kindly grant weeks time for filing.
How much?
Lord,
You
2
are
weeks.
appearing for
11th respondent. Lord, respondent.
Direct counsel for respond number 11 press friends granted a week's time to 3 weeks time.
3 weeks.
3 weeks time to enable him to file counter.
23 months.
Apply.
4 weeks then, make it 4.
4 weeks.
Now,
So I am for respond number 3, your lordship. Respond number 1 and 2 has to answer your lordship.
huh?
Okay.
You are appearing for R3.
Yes, sir.
None appears for this.
None for petitioner.
None for petitioner, list after 4 weeks. Yes.
I'm appearing for the petitioners, my lordship. My lordship, I am filing this writ petition for writ of certiorari against the order challenging the order issued by Lokyukta of Telangana. My lordship, the petitioners are the owners and possessors of the agricultural land in survey number 256, Dacharam village, and that land was acquired by respondent number 3.
Yes, ma'am. The last occasion note, the complainant in the local collector is likely to be implemented by the petitioner.
So have you filed an implead petition?
We have impleaded, we have submitted a petition, my lordship.
Admission some date, Monday.
I think IA4 is that implead petition.
Allowed, allowed, madam?
Yes, my lordship.
No, madam, it has not been allowed.
Not allowed.
4 of 23, reasons assigned.
Filed on 57.
Heard on IA 4 of 23 for the reasons assigned in the application duly supported by an affidavit, same is allowed. Let amendment be carried out by the registry within 1 week, list thereof.
Notice may be.
Notice to impleaded respondent.
Issue notice to impleaded respondent.
Much of that.
3 weeks later. After 2 weeks. Yes.
May I please, lordship, I am appearing on behalf of the petitioner, lordship. Last occasion, they have taken time for the file counter, lordship.
Who
has taken time?
Respondents.
let counter, if any, on behalf of respondents be filed within a period of 3 weeks.
Much of that.
Around 6 and on 8, it's filed by.
None for the petitioner
Respondents inside 8.
awaiting appearance, hearing deferred, list after 3 weeks.
Counters have been filed by 1 and 3 members.
What you want to file any rejoinder? What?
I am, lordship, I am for the respondent number 12. 2 weeks time may be granted.
Filed by counter.
None,
Sir,
sir.
namaskaram, sir. 104.
You should be here. Why are you staying? All right. Yes.
Party number, sir. Sir, we are Bhadrati Kothagudi.
105 నెంబర్ పిలిచిన 104 అయిపోయింది పిలిచినప్పుడు ఎవరు రాలేదు
ఇక్కడే ఉన్నా సార్ మాట్లాడుతున్నాను.
వాట్ వి కాల్డ్ ఇస్ 105
Yes, I filed counters on behalf of 1 and 3.
104 ఏమైంది 3 వీక్స్ డేట్ వస్తుంది సిస్టమ్ లో చూసుకోండి
3 years అవుతుంది సార్. ఇది పబ్లిక్ ఇంట్రెస్ట్ పర్పస్ ఉండే ఫిజికల్ హ్యాండ్ క్యాపిటల్.
That's why you shouldn't bother, right? Public interest, we have taken note.
అవినీతి కోట్ల రూపాయల అవినీతి అక్రమాలు సార్.
Date we will give.
ఐఏఎస్ ఆఫీసర్లు
No,
పట్టించుకోవట్లేదు,
date.
కోర్టులు
Which
పట్టించుకోవట్లేదు.
date you will argue? Tell us a date. What date?
సార్
We will give you a date today. No time left.
రేపు ఇచ్చినా ఓకే సార్, రేపు డేట్ ఇచ్చినా కూడా.
24th August. List on 104. List on 24th August. 105. Yes.
File counter 1 and 3. Respond. The other respondents are filed.
Nobody appears. None for the petitioner. Counter has been filed on behalf of respondents 1 and 3.
1 and 3.
1 and 3. When we can
Chief Secretary and the collector.
28th August 24.
Respondent.
Obliged.
Yes, what is it?
Attempt to commit suicide.
Yes, Mr. Praveen.
Yes.
Attempt to commit suicide, my lord. The memo is filed by the state government.
We have filed our counter.
Who? 2, 3, 4.
Yes.
3, 4.
Counter on behalf of respondents 2, 3 and 4 has been filed. Let counters on behalf of remaining respondents be filed if so advised within a period of 3 weeks. 4 weeks. 4. 4 weeks. 4 weeks.
Yes, next.
Petitioner is present on
Huh?
the petition and counter not yet filed.
We need to file a counter.
Huh?
Need to file request some time for filing a counter.
Learned special GP, what praise for a special counsel, praise for is granted.
2 weeks.
3 weeks time to enable him to file counter.
Deeply obliged.
May it please your lordships. My lordship, I am for respondent number 11, lordship. Your
Learned
lordships, I am appearing for petitioner, your lordship. The present public interest litigation related to illegal transfers are been made in agency lands, your lordship. There is a clear legislation and also Supreme Court have multiple times held that the agency land cannot. We have filed 2 IAs, your lordship may see, IA2 and IA3.
No, this is what relief is vague, omnibus relief, public interest litigation. Petitioner may either withdraw public, file a fresh petition, take steps for amendment of petition.
To that regard, your lordship, we have filed IA2 and 3. One is for amendment of prayer with regard to
When have you filed this IA? Learned counsel for the petitioner states that in compliance of the order dated 28/7/2022 passed by a division bench of this court, petitioner has filed an application seeking amendment of the writ petition, namely IA number
IA2. We have filed both the IAs, your lordships. IA2.
He has filed interlocutory applications, namely
2 of 2022 and 3 of 2022.
Only three is amendment of prayer.
Yes, your lordship.
I has filed IA3 of 22. What amendment?
Amendment is sought with regard to that particular village, your lordship, that survey has to be conducted and illegal transfer which are in favor of non-SCs that has to
Taking
be.
into account the nature of proposed amendment and for the reasons stated therein, same is allowed. Registry to carry out amendment within a week.
And one more IA, your lordships may see. One more IA is to implement the Gram Panchayat of that particular village. Your lordship.
We need to notice of that IA.
We did not receive a.
Hold on, IA, what?
We did not receive copies of the
petition.
petition
Notice to propose respondent.
The lordship may direct the respondents to file their counter by next.
Notice to propose respondent.
Furnish their copies, my lordship. They did not furnish the copies. I am obliged.
Yes.
May I hold your lordships back for only 1 minute, minutes. Items 121 to 125.
86 of 2020, 110.
No. The bell rang, so I thought your lordships were raising.
No, 110. We'll finish up to 120, then only get up. Don't worry. Yes. What? Rashtriya Van Samiti. Oh, monkey menace, right? Construction take place on the. What? Let objections counter if any on behalf of respondents 1, 3, 4 and 5 be filed within a further period of 3 weeks. Next.
Yes. Your lordships, I am for the petitioner, your lordships.
Your
lordship, this public interest litigation, your lordships, has been filed challenging the lordship's reconveyancing of the land.
This has been issued, no.
Your lordships, note, there's a status quo order, your lordships, on the last occasion.
I need to file a counter.
Learn
to file a counter.
Special counsel praise for how much time?
3 weeks.
Which respondent you please tell us?
Official respondents.
Official respondent praise for is granted 3 weeks time to enable him to file counter. 4 weeks time. 4 weeks. Next.
Status quo order may be extended.
Interim order granted on earlier occasions shall continue.
Deeply obliged.
Learned counsel for respondent 5, 7 and 8. Praise for. Last indulgence, Mr.
My lord, 1 to 4 also, my lord.
Why are you not responding? Fake ORS products.
ORS product, not there, adulteration.
It's a serious, genuine public issue, right? Why? So and so pray for adjournment. Learned counsel for the petitioner brings to the notice of this court earlier order passed by a division bench of this court on 19/7/2023. Line below, it is made clear that in case counter is not filed within a period of 2 weeks, appropriate orders shall be passed. List on 14.8. None for the petitioner. On notices made, they have been served, madam.
Madam, shouldn't notices surviving?
Notice
appears for the petitioner on.
Let counter, if any, on behalf of respondents be filed within a period of 4 weeks. Ah. Three docs, petitioner has to file an affidavit. None for the petitioner. Let directions contained in the order dated 7/12/2022. 7/11/2022 be complied with by the petitioner within a further period of 3 weeks. Who are you? Learned counsel.
R4. We also file counter.
Whatever respondents R4, 2, 3, 5 and 6, whatever their description, they are not telling. Pay for
District collector.
No, GP.
Special GP, whatever services, revenue, pray for and granted 4 weeks time to enable them to file counter. What happened?
Yeah.
Counter?
The respondents that file the counters.
Yes, that's what we are saying. Let counter, if any, on behalf of respondents be filed within a within a period of 4 weeks. Now counter on behalf of R9 filed. Let counter, if any, on behalf of remaining respondents be filed within a period of 4 weeks. Yes.
Counter needs to be filed. I pay for the response.
GP for revenue praise fund is granted. How much time? 4 weeks time to enable him to file counter.
Yes.
Yes, Mr. No, counter is right. What is it? Counter?
Counter of R7 file, but
GHMC.
Counter on behalf of respond number 7 has been filed.
3
Let
and 5.
counter, if any, on behalf of respondents 3, 4 and 5 be filed within a further period of 3 weeks.
3 to 5 are already filed a counter.
No, 7 is filed.
7.
3 to 5 also. We are already.
Counter, if any, on behalf
Yes.
of nobody is appealing. What to do? Yes.
I'm representing. I filed an application, my lord, for demarcation of the lands of the school as well as the unofficial respondents.
The notice has been issued, right? Yes.
We have filed my counter.
They filed counter, my lord. I filed reply also, my lord.
R7 has filed.
R3, my lord.
R7 not filed counter, my lord.
Let
For
counter,
R7 lordship in this matter.
let counter, if any, on behalf of R7 be filed within a period of 2 weeks. List on 22nd August 23.
In the meanwhile, the IMA be ordered, my lord, IA2 of 2023 for demarcation of the lands of the school as well as the land parts of the unofficial respondents, my lord.
IA4 of 23 shall be considered on
2, my lord.
2 of 23 shall be considered on the next date of hearing. List on 22nd August.
The urgency is, my lord, they have constructed a building in the school premises and they are losing the playground, my lord.
Please see the time. That's why.
Next week, my lord, I'll argue that. Next week.
Next week thing happens. This is a public interest litigation, right? We will take care. Don't worry. This land belonging to the government won't go anywhere. You are in safe hands now.
Well, there is a direction to file a report, my lord. Status report is ready, my lord. Tomorrow I am filing it.
Learn it. What is your
GP for home, my lord.
GP for home? Submit that in
678.
3467 submits that in compliance of the order dated 28/6/2023, report shall be filed on
Tomorrow.
shall be filed by tomorrow. List in the next week, 14th August 23.
Appearing for 7th respondent in this matter, Lordship.
And what about this again, admission and hearing?
No, there are a couple of notices which will pass over.
Pass over, yes.
Yes, items
1 minute, one. Still pass over matters. Yes. Yes. Oh, Mr. Senior Counsel, we really kept you waiting.
No, brother, it's a pleasure hearing your Lord's fellow.
No.
Lord's fellow, complete the entire business.
We would have, yes. What date can we hear, brother? On a date, which account, now we are maintaining this so it doesn't happen. So situation will be slightly uncontrollable because we don't, all these matters have come up because previous benches have fixed. So that's how tomorrow is also heavy day.
Any convenient date of
140 matters.
140. So we want to give you a clear date. So that's why we are maintaining a calendar.
Yes.
Looking into what is this thing.
17, 14, we have given couple of days. And again, 22nd, it is 21st.
We can take up time. 17th August. Yes. Sorry for having kept you waiting. Mark the presence.
Continue.
Yes, learned, mark their presence of learned senior counsels. Interim order grant on account of paucity of time, the matter could not be taken up. Interim order granted on earlier occasion shall continue. List on 17/8/2023. Which case, madam?
These three matters gets over. There is one
30,
matter of,
31 and all right.
Then next pass over.
Next pass over, which is it?
Here, there. Mr. Vedula Venkat.
No, this is hearing. That will continue, madam. Don't wait. No, don't pause. This is final hearing. This now come to admission again. This board is continuing tomorrow also, right? Your cases. Admission and hearing, not submission.
Tomorrow, Your Lordship, may please to take up this matter day after tomorrow.
Day after.
61 item.
Day after.
61 day after tomorrow, right? All right. 61 day after tomorrow.
So we have not taken up these matters. This board will continue to know.
40, no point.
That's what.
So this thing 62 to 64 also, what date?
We can go with the later. 23rd.
23rd August, right?
62, Mr.
62, 63, 64, 23rd August 23.
63 and 64, Lordship.
23rd August. Yes. Next.
Because tomorrow we have 140 matters.
140, not possible. There's no point in keeping all of you waiting. We want to be realistic when it can be taken up. Yes, 121, madam.
Yes.
Admission and hearing.
Items 121 to 125.
As far as come, we didn't want you to mention out of turn.
No, these matters, my lords, have been heard multiple number of times.
121 to
121 to 125.
Yes.
These relate to child trafficking, child labor and all that. Reports are fine. Your lordships may have it one afternoon, my lords, after 3 weeks, tentatively subject to your lordship's calendar.
29th August.
Yes.
Mark the presence on account of paucity of time. Matter could not be taken up. List on 29th August 23.
Okay. That's 121 to 125.
121 to 125. Next.
126.
Appearing for R3 Millard. Appearing for R3 Millard, GP for land legislative affairs.
You have filed your counter, right?
R3 Millard, I am.
You have filed counter. Not filed.
Nothing. Counter is not filed.
Yes, Millard.
You don't want to file.
2 weeks time may be granted, Millard.
You should
Still-
tell that. no?
What are you waiting for? Learning council for strong number 3. Praise fund is granted. 3 weeks time, 2 weeks, 3 weeks time to enable him to file counter.
Yes, next.
Same, right? Connected, no, madam. Acha,
Both are
126, 127 are connected.
connected, interconnected
It goes
along with.
along with that. Then
Therefore, the
we'll give dates. Some dates. No point continuing.
128 and 129. 128, you give it 2007, 30th of August. 129,
30th August, madam.
then 129, give it on first week of September. 5th,
What
5th
date?
of September.
5th September.
129. Then final hearing matters of 2006 will be on 31st of August. 2007 final hearing matters will be on 5th of September. 2008 will be 12th of September. Then 17 will go to 18th September. 2017 matters. 2017 matters will go to 18th September.
What is the envelope? Probably some record of some case.
Last one.
Okay, madam, noted the dates. Noted. That's it. Yes, Mr.
It's a good, sir.
Which case?
My lord, somebody.
No. We are only now segregating year-wise so that, there is no need to wait 2018 matter till this thing, so that some systematic approach need to be adopted. Otherwise, every matters, 200 matters coming on one day, humanly impossible to go through the board.
My matter date has been given.
Date has been given. Okay.
132. DP applied.